All right, Mrs. L, which case are we calling first?
If we could actually start with the Jeffrey Tabor case.
Okay, Jeffrey Tabor.
And Ms. Thompson will be handling that case.
All right.
So she will need to make a motion.
All right, so we're on the record in docket 240137-373. That is City of Lansing, or people of the state of Michigan versus Jeffrey Tabor. Appearances for the record, Ms. Thompson, and you have a motion.
I'd like to make a motion to practice under Michigan Court Rule 8.120.
All right.
My supervising attorney is APA Gabrielle Izell.
All right. That's granted, and you only have to make it one time today, right? Oh, and you will need your full name for the record.
Laura Thompson for the people.
Okay. From the defense.
Good morning, Your Honor. Justin English on behalf of Jeffrey Tabor, who is here to my right.
Mr. English. And sir, you are Jeffrey Tabor, is that correct?
Yes, sir.
Right, thank you. This is the time set for final pretrial on today's date. Ms. Thompson, how are we proceeding?
We've offered a plea to Mr. Tabor for pleading guilty to an added count 2 of assault and battery, and we would drop count 1 for the aggravated assault and battery.
All right, and Mr. English, that's the offer that's been made. Are you accepting the offer? Or are we setting this for jury trial at this time?
I don't think that's a correct offer, Your Honor.
All right.
No contest.
Oh, I'm sorry. It was a no contest plea. There's also an agreement to no upfront jail and a restitution hearing at a later date.
All right. So is that your understanding of the plea offer? It's a no contest to count 2 of the regular assault and battery?
It's assault, but no contest to assault and battery, no upfront jail, restitution, reserve the right for restitution hearing if needed, and then any alcohol treatment based upon unbelievable alcohol assessment.
And the factual basis for the no contest plea, first of all, you're taking that.
We are.
All right. So the factual basis would be sent to or emailed to one of my staff. Or do you have the email, the factual basis?
I can email it to the staff.
Okay.
If you give me one
Either
minute.
or, I can take it in hand as long as we've agreed to the facts of the case.
Yes, I simply don't have it printed out, Your Honor. I can have it emailed to Ms. Holden in 2 minutes.
All right, so Mr. Tabor, I'm going to reiterate for Mr. English and the plea agreement. And if that's your understanding, this is a plea to a count 2. They have no contest. To amended count 2 or amended count 1. I don't know, depending on what judge you have. But we amend count 1 to assault and battery. And the purpose for the no contest plea?
Due to intoxication and lack of memory.
Okay. There's a Killebrew agreement of no jail. Is that fair?
Yes, Your Honor.
And then if the court requires that sentencing, we'll schedule a restitution hearing. If there's a problem determining restitution. Is that a fair statement?
Yes, Your Honor.
And then any assessment, any alcohol assessment will be provided to probation for any matters concerning alcohol.
That's correct, Your Honor.
And Mr. Tabor, that's your understanding, is that correct?
Yes.
All right, thank you. All right, well, we're waiting for as you know, it takes a little time to get the emails. Sometimes they come quickly, sometimes, but I will read you through your rights today concerning no contest plea. All right, sir? You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question the witnesses that are brought against you. You are represented today by Attorney Justin English and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, Your Honor.
You'd have the right to have the court order any witnesses appearing in your defense to remain silent during the trial, not to have that silence used against you in a testified trial if you choose to testify. If your no contest plea is accepted, you'll give the claim the no contest plea was the result of any promises other than what we've stated on the record or threats that it was not your choice to plead guilty. If you're giving up the right to have a trial, if you appeal, so there's nothing to appeal except for the no contest plea. All right. I just heard the printer, so I don't know if that was.
She's
I'm
highlighting.
sorry.
Judge.
Okay, approach.
You made it, Mrs. L. Thank you. All right, so I'm in possession of the no contest of the police report. This is 245-190-2906. And this would be used as the factual basis for the no contest plea. Is that a fair statement, Mrs. L?
It is, Your Honor.
Mr. English?
Yes, Your Honor.
Ms. Thompson,
Yes.
also, okay. You had Mrs. L running around for the no contest plea, so.
And Your Honor, it is the start of the highlight. It's the entire portion that is started to be highlighted. I just kind of.
All right, so we're looking for an assault and battery that occurred on March 31st, 2024 at the offense location of 1215 East Michigan Avenue in the city of Lansing, Ingham County. Date and time were provided by the Lansing Police Department narrative, William Churvo, that this had occurred on 12/15 at the March 31st date. It appears that the defendant, Mr. Tabor, is accused of making offensive contact with LJ Knight. That would be the best basis for that. This is Jennifer Boland. Oh, Boland is the LJ Knight was reporting to the officer that the offensive contact was made to Jennifer Boland. On that date and time. Anything towards the factual basis for assault and battery concerning the victim, Ms. Boland, for the offensive touching of Ms. Thompson?
No, Your Honor.
Mr. English?
No, Your Honor, I think you covered it.
All right, I find the no contest plea to be, and for the record, the no contest plea was done for intoxication and lack of memory. No contest plea to be knowing, voluntarily, and accurately made. And we'll refer to probation. So, Mr. Tabor, probation's one floor down, all the way to your right. Mr. English can show you where they'll either set up an appointment now or they'll see you now. I'm not sure what their schedule is like, but they're going to prepare a report for me, and we'll see A, what restitution is. That's still undetermined. And then B, we'll see what alcohol assessment is once the assessment comes to the probation department. That sentencing date will be, and then Mr. English, you should check with your schedule just to make sure the date works.
November 4th at 1:30.
Does November 4th at 1:30 work for your schedule?
It does, Your Honor.
Okay. So set it for November 4th at 1:30. We'll refer to probation on the assault and battery. Anything else for the record in docket 2401-373? Ms. Thompson?
No, Your Honor.
Mr. English?
No, Your Honor, thank you.
All right, you should be all set, Mr. Tabor. I'll send that November 4th date, all right? And I'll return the police report.
Thank you.
Ms. Thompson, everybody does that a little, no contest, please. They grab that a little different. So sometimes they email it to the staff. Sometimes they just hand it over. It depends on who you're in front of.
Prepared, like
Yeah.
I was.
It just depends on who you're in front of. So, all right, Mrs. L, where are we heading?
Good question. I believe we are ready on the Kylie Cross case.
Kindly cross. And Mr. Ned, is that your case or Mr. Harry's? All right, so we're on the record in docket 25-01361. That is the People State of Michigan versus Kylie Cross. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Ned.
Georgia Net APD on behalf of my client standing to my right.
And ma'am, you are Kylie Eileen Cross?
Yes.
Thank you. This is time set for a final pretrial in the matter. Mrs. L, how are you proceeding?
Thank you, Your Honor. At this time, the people are asking for this case to be set for a jury trial. We need to be honest with the court. The necessary witness is not here today. She was subpoenaed. However, she had a conflict with a different court case in a different county. It was set for the same date and time. She was willing to try to sit on Zoom while in that courtroom to attend here, but I told her that would not be a great idea. I do understand that it's the defense's intention to move for a dismissal today. We would ask for that one more opportunity to bring the victim in, as this was just a scheduling conflict.
Right, so you've had a contact with the victim. You understand the nature of the non-appearance, and your request is to set for jury trial.
It is, Your Honor.
Mr. Ned.
This is my understanding, the second failure to appear. The complaining witness did not show up for the first final pretrial or this one. I'd ask the court to dismiss this case without prejudice. Of course, the prosecution can always reissue if needed.
Yeah, I have a prior fail to appear on July 29th of the defendant that a bench warrant was issued. With that understanding, we'll see where we are in a jury trial, okay? So we'll set this for jury trial on
October 21st at 8 a.m.
8 a.m. So it's set for October 21st at 8 a.m. I think that is a Tuesday. So Monday's that is October 21st is a Tuesday.
Today's Tuesday, sir.
Right. And we've set it for October 21st.
Yes.
Okay. And October 21st is a Tuesday. That's all I asked.
Oh, okay. I'm sorry. I was like.
That's all I asked. So it would appear that we'd have to know by Monday night if this is going. Anything else for the record in 25-01361?
Not for the people. Thank
Mr.
you.
Ned. All right, Ms. Cross, we'll see you on that date. Thank you for your appearance. It's got a lot of dates. All right, Ms. Zell, where are we heading next?
All right, I do believe we are ready on Justin Gallegos.
There you go. All right, so we're on the record in docket 25-02262. That is People of the State of Michigan versus Justin Gallegos. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Justin Gallegos, who is standing to my right, Your Honor.
Sir, you are Justin Gallegos, is that correct?
Yes, Your Honor.
All right, thank you. This is time set for a final pretrial on the matter. Mrs. L, how are you proceeding?
Your Honor, at this time, a plea offer has been extended to defense through defense counsel. It is my understanding that offer is going to be taken today. That offer would be to plead to the count 1 of domestic violence with an agreement to no upfront jail. I will defer to Mr. Harris.
That is correct, Your Honor. My understanding was there was some discussion of 7694A status, but that Mr. Gallegos would not qualify for that. I have discussed that offer with Mr. Gallegos. He has indicated that he would like to accept that offer at this time. While I was going over what that plea would likely entail, he indicated and was going over the likely factual basis. He indicated that he was having some trouble remembering, so I believe we might need to enter a no contest plea here as opposed to a guilty plea.
If this is it, so it'd be a no contest plea. Is that acceptable to the prosecutor? And then we need something for the factual basis.
I would ask for maybe a little bit more of a basis as to what the memory issue is. If we would be able to get that factual basis on a guilty plea, the people would prefer that at this time.
All right, well, so there's some question whether the offer would include a no contest plea, which is completely, would be the people's discretion. With a Killebrew, no jail, that's no upfront jail would be the kicker. I mean, that's the sentencing agreement. So Mr. Harris, did you need some time to talk to Mr. Gallegos concerning the no contest plea or whether he would be able to make a factual basis on his own?
I did try and go over some of the incident and some of the occurrences and what was alleged to have happened that day in the police report. He indicated that he can remember bits of it, but not the entire exchange, and that he has trouble remembering what happened that day. He indicated that he would not be disputing what was alleged in the report, Your Honor.
All right, so it does I'm kind of putting you on the, I can set this for jury trial and have it work itself out, or we can set it for plea date, a no contest plea date.
No, Your Honor, I think at this time the people would be okay with the no contest plea being.
All right, so do you want to send or provide a factual basis, and then we'll go from there. Mr. Gallegos, Mr. Harris, and Mr. Gallegos, that's your understanding would be a no contest plea for lack of memory to the domestic assault with a Killebrew, no jail. Is that a fair statement?
Yes, Your Honor.
All right, and then we'll use the police report as a factual basis for the no contest plea. Mr. Gallegos, you understand you have the following rights in this matter. First of all, is that your understanding of the plea offer?
Yes, Your Honor.
Right. You have the following misdemeanor jury trial rights, and I'll walk you through those rights. You have the right to be tried by a jury, to be presumed innocent and proven guilty. You have the prosecutor prove beyond reasonable doubt that you are guilty. You have the witnesses against you appear at trial to question any witnesses that are brought against you. You were represented today by Attorney James Harris. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, Your Honor.
You have the right to have the court order witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your no contest plea is accepted, you'll give up the claim the no contest plea was a result of any promises other than what we placed on the record, or threats that it was not your choice to plead guilty or plead no contest. You'd also be giving up the right to appeal anything from trial, since we won't be having a trial today. You'll be pleading no contest to the domestic assault charge. Is it still your wish today to plead no contest to the domestic assault charge?
Yes.
Okay. All right. So I'm going to have that printed off.
I don't have it.
What's that?
I don't have it yet.
When we get it, I'll have it printed off, and we'll do the no contest to the domestic assault charge. All right, so we're on the record, back on the record in 25022262. And I'm in possession of incident report 25028336, which is the factual basis for the no contest to the domestic assault. And you're stipulating to the court using this as a factual basis. Mrs. L, you provided this to the court, so.
We are, Your Honor.
All right, Mr. Harris.
Yes, Your Honor.
All right. So this all occurred on July 24th. This is a Lansing Police Department by Thiessen Graham, incident 25028336. It appears to happen on July 24th, 2025 at 135 South Clemens Avenue in the city of Lansing. It was indicated that Kelsey Gorankowski had been in a dating relationship on that date with Mr. Justin Gallegos for 2 months, which makes it the domestic violence. And the allegation that's uncontested is that Mr. Gallegos lunged at Miss Gorankowski and then grabbed her left leg and began to pull her off the couch, which would account for the offensive touching of another under the domestic violence, and that they've been in a dating relationship. Anything else for the record or the factual basis in docket 25028336 or 25022262, I should say. That's our file number. Mrs. L.
Not for the people.
Mr. Harris.
Not from the defense, Your Honor.
Okay, I find the factual basis to be knowing, voluntarily, accurately made, and will refer to probation. So Mr. Gallegos, probation is 1 floor down all the way to the right. And you can go see them. They'll prepare a report for me and we'll see what options are available to us at sentencing. And a sentencing date will be for
November 4th.
November 4th at 1:30. So I'll see you again on November 4th at 1:30 for the sentencing. Anything else for the record in 25022262, Mrs. L?
Not for the people.
Mr. Harris.
Not from the defense, Your Honor.
All right, Mr. Gallegos, we'll see you on that date.
Thank you.
And then I'm going to provide the police report back.
May I approach, Your Honor?
You may.
Probation. Police report.
Yeah, I think that came from Mrs. L. All right, thank you, Mr. Harris. Then, Mr. Ned, were you ready on Mr. Boyd?
Yes.
All right. Only because we don't know how long we have, Mr. Boyd.
I do have the amounts. If you want them.
All right, Mrs. O, is your preference to have these called separately or together?
They can be called together, Your Honor.
All right, so we're on the record in docket 25021110 and 25023004. That is people of the state of Michigan versus Tony Boyd. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle, fellow assistant prosecutor for the people.
Mr. Ned.
George and Ed, APD on behalf of my clients appear to be in Salt Lake County today.
And sir, on both files, 25021110 and 25023004, you are Tony Maurice Boyd?
Yes, I am, Your Honor.
All right. And you can hear me all right, Mr. Boyd?
Yes, perfectly clearly.
All right, thank you. This is the time set for pretrial in the matter. Mrs. L, how are we proceeding on both of these files?
Your Honor, at this time, a plea offer has been extended. That plea offer would be to plea to the retail fraud third in the, let me get the case number here, in 25-02304. I believe that's the correct one. Upon proper plea and sentence to that charge, we would be dismissing the other file. There would be an agreement to pay a combined restitution for both files. And the people will be submitting pink sheets for those amounts.
All right. Is that your understanding of the plea offer, Mr. Ned?
Yes, sir. Is 2304 the retail fraud third file?
Yes,
So plead guilty as charged, dismiss the other file as a second,
right.
with restitution stipulated too.
With, yeah, the restitution on both files to be determined at sentencing, I would think, or
Because
We do have the correct amounts today. I can submit the pink sheets or it can be determined by probation.
is this a case that would go to probation or not?
It doesn't need to.
Okay, all right. So, Mr. Net, I would assume you're asking for immediate sentencing.
Yes, Your Honor.
Once we figure out what the restitution is. So it's plead or charge and restitution on both files.
Mr. Boyd, can you hear me?
Yes, I can.
So everything
Yes.
worked out as planned. The only difference is we have to agree to restitution. Do you want to agree to restitution today and get this over with?
Yes. Yes. Sorry about that.
All right, so Mr. Boyd, the plea offer, as I understand it, is plead as charged, the retail fraud third, restitution be determined on both files and be submitted by pink sheet by the prosecuting attorney. With a successful plea and sentence, will dismiss the retail fraud second, which is 2502110. And the request is for immediate sentencing today. Is that your understanding, Mr. Boyd?
Yes, it is, Your Honor.
All right. All right,
Can
you
you
have
hear
the
me?
following rights in this. Say it again, sir.
Can you hear me?
Yes, I can hear you just fine.
Okay, thank you.
All right, you have the following rights in this 2502304 retail fraud third case. And I'm going to walk you through those rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by Attorney Georgeson Ned, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, I do, Your Honor.
You have the right to have the court or any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give the claim the plea result of any promises other than what we placed on the record or threats that it was not your choice to plead guilty. You'll also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the retail fraud misdemeanor in the third degree instead. Is it still your wish today to plead guilty to the retail fraud third degree misdemeanor as a part of this agreement?
Yes, Your Honor. Yes, indeed.
I'm going to have you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I do, Your Honor.
All right. I'm going to bring your attention back to April 27th, 2025 at 6200 South Pennsylvania Avenue in the city of Lansing. Were you at the Pennsylvania address? That's usually Meyer on April 27th, 2025.
Yes, Your Honor.
And at that time, did you take property? Was Meyer open to the public at the time?
Yes.
And did you take property from Meyer under the amount of $200?
Yes, Your Honor.
And what property did you take from Myers?
I can't remember, Your Honor. It's been a while back.
All right.
Sorry.
You do not contest that the allegation was some clothing, some meat products, and a hand lotion.
Yes.
All right. And those all totaled under $200. Is that correct?
Yes, Your Honor.
And at the time you took them, you didn't intend to pay for them. Is that correct?
Yes.
All right. Anything towards a factual basis, Mrs. L?
No, Your Honor.
Mr. Annette?
No, Your Honor.
All right, we have restitution on both files. So the two pink sheets and the dolly from, wow. So the pink sheet on 250202304 would be for $153.17. On 2502110. Do you want that in the dismiss file or in the action file? That would be in the amount of $232.51. So that's an agreement on restitution, and I will place both pink sheets in the plea file, which is 25-02304.
Can you say those 2 amounts again? I apologize.
Sure.
153.17 and then
153.17 and 232.51. And that's over $300 we can refer to collections, I think. So, so the request is for immediate sentencing. Any objection to immediate sentencing, Mrs. L?
No objection, Your
All
Honor.
right. Allocution, Mr. Annette.
And thank you. Mr. Boyd apologizes for his actions. He understands it was a mistake, and hopefully once he's released around January 22nd of next year, he'll make better choices. He informed me they want to apologize to the court for wasting everybody's time for being here. And I don't know if he has anything else to say, Your Honor. Thank you.
All right, Mr. Boyd, do you have anything to say to the court before the court passes sentence on the retail
No,
fraud
Your
third
Honor.
file? All right,
No,
thank
Your
you.
Honor. Just remote. No, Your Honor.
All right, thank you, Mr. Boyd. Mrs. L, anything you'd like to say to the court?
No, Your Honor, we leave this to your discretion.
All right. So we have a plea as charged. There was $100 cash surety on this case for the bond.
I believe that is correct, Your Honor.
How many days does he have? So do we have that?
I don't think he's held on this.
I'm assuming he's held on another file, but I don't know if he made bond on by July 31st on this one. And then if he was bonded out on the misdemeanor, he'd have 3 days.
3 days on 2110.
Two, 2304.
That was a misdemeanor, so he PR'd on that one then. 4 days.
So 4 days.
4 days.
All right, so I'm gonna send the defendant to 4 days. With 4 days previously served. Restitution would be paid in the amount of. Do some math, add these up, I'll give you a. $385.68. That's the entire rate of restitution to go to Myers and Target.
Okay.
The fines and costs, $100 fines, $100 costs. Crime victims' rights fee of $75, state fee of $50. For a grand total of $325. So it's $325 plus the $385, and that'll be referred to collections.
Okay.
Since you won't be out till after the new year on another file, because you're being held on another file. Is that correct, Mr. Boyd?
Yes. Yes, Your
All
Honor.
right. So that'll be referred to collections. So once you get out after the new year, come to the 54A District Court Collections Department. I believe it's Marquita as the collections department.
Just a correction. I was informed he gets on New Year's. I'm not sure if that's what he reported to me.
Right.
Just wanted to make that.
Whenever you get out, you got to refer to collections. You got about a $600 in restitution. The restitution will be paid up front, and then you have another $325 in fines and costs.
No problem.
All right.
Thank you.
Anything else for the record in 25-02304, Mrs. L?
Not for the people. Thank you.
Mr. Annette.
Thank you.
All right, Mr. Boyd, you should be all set on these two files. Thank you for your appearance today.
Thank you, Your Honor. Have a nice day.
You too.
Yeah.
Did I tell you that? She's gonna.
Did I send an Ollie on that?
That was gonna be my next one.
I don't know if I signed an Ollie on that. I know Mrs. L signed it. I don't know. I can't remember if I signed it. Or not. If you say so, I did. Because I can't remember.
Oh, I can't remember. Amend count one.
All right, Mrs. L, where did you want to head next?
I believe we will be ready on George Slater in just a moment.
All right, Slater.
Sorry, I'm in a Slater. Okay, we are ready on Jordan Kiss.
Jordan Kiss. Two files.
Same file, Judge.
Oh. 2291. Okay.
One's for a 53 violation.
All right, so we're on the record in docket 25-02291. That is People of the State of Michigan versus Jordan Kiss. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zealous, Assistant Prosecutor for the People.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Miss Jordan Kiss, who is standing to my right, Your Honor.
And ma'am, you are Jordan Kiss, is that correct?
Correct.
All right, thank you. This is time set for a PA 53 and a final pretrial. Mrs. L, how are we proceeding?
Your Honor, at this time, the people's necessary witnesses have failed to appear. I will say we did not have proper service with their subpoena. However, they have been in contact with our office and they have let us know that they did not want to move forward on this case. We do expect a motion from the defense at this time.
That is correct, Your Honor. At this time, given that the complaining witness has failed to appear and has indicated they are not interested in proceeding with the case, I would ask that the case be dismissed and a copy of the dismissal be provided to my client, Your Honor.
All right, so in regards to the 25-0002291, this is the actual file. How are you proceeding on the PA 53?
Your Honor,
Is that a part of the?
Yeah, we also don't have the necessary witnesses to move forward on that today.
All right, in regards to 25-0002291, the actual file, people are unable to proceed. Contact was made with the complaining victim, and they indicated that they were not going to appear today. So the motion was made by the defense. That motion will be granted. The default, Ms. Kiss, is this is dismissed without prejudice, which means that people could reissue if they choose to, based on new allegations or review of the file. But for our purpose today, the case is dismissed. I do have a no contact order, so you should probably carry this with you because it'll take about 4 hours to get all this purged from the computer system. But I will grant the dismissal made by the defense. And you can get a copy made for you by my court officer. And then we'll also dismiss the PA 53 violation, as similarly contact was made with the complaining victim, indicated that they were not going to pursue this charge, And therefore, the people have moved, people have presented this evidence, and the court will dismiss the PA 53 violation at the request of the people. Anything else for the record in 25-02291, Mrs. L?
Not for the people.
Mr. Harris?
Not from the defense, Your Honor.
All right. Ms. Kiss, good luck to you. You should get a copy and keep it with you just for the afternoon, because it'll take about 3 or 4 hours. Okay. On the cell phone, 517-719-2449, could you please identify yourself?
Jamar Lackey.
Jamar.
That's my
All right, Mr. Lackey, you're here for your 9:30?
Yes.
All right. Stand by, you're in the right place. We'll call your case in just a second. Actually, a few minutes.
Thank you.
Ms. Adhikari, what case are you here on? And you'll have to unmute, ma'am.
Hello, sir. Can you hear me?
I can.
So I am a Nepali interpreter. I'm here to interpret for a Nepali client.
And who's your client, ma'am?
Unfortunately, my client's name is not revealed. Probably it's because of the law thing.
All right.
Let me double check my party. Okay, it says Bimal.
Yeah, I'm wondering.
They're on Zoom because that's the only way Bonnie can get them here.
That's fine. I just want to know who the client is.
Okay, I can see the client's name now. My party had sent me, and it says Bimal Magar.
Bimal Magar. All right.
Yeah.
All right. And Mr. Ned, is that your client or is that Mr. Harry's?
Not mine. To my understanding.
Your Honor.
Taylor,
All right, so we're on the record in docket 2502-354. That is People of the State of Michigan versus Mabel Rayler. Appearances for the record, Ms. Thompson.
Laura Thompson for the people.
Mr. Net.
George Annette, APD, on behalf of my client, saying to my right, Your Honor.
And ma'am, you are Mabel Louise Rayler?
Lois.
Lois, thank
Yes.
you. Thank you. This is the time set for a final pretrial in the matter. Ms. Thompson, how we proceed?
The victim was subpoenaed and indicated to us that he would not appear today. Since the people's necessary witnesses have failed to appear, we expect a motion from the defense.
Mr. Net.
Thank you, Your Honor. I believe the complaint witness was also here yesterday and said open court, he wasn't showing up. I'm not sure if the court heard it yesterday during the landlord tenant matter. Regardless, my client maintains her innocence and we're asking for dismissal without prejudice, of course, and a copy of the dismissal for my client.
So contact was made with the complaining victim and it was unsuccessful.
Yes, Your Honor.
All right, so we'll print out so I'll grant the motion to dismiss without prejudice. The request of defense. On docket, so I'm in possession of the order of acquittal or nollie pros on 2502-354. The request is granted without prejudice, which means Ms. Rayler, the people could reissue if they choose to, but for our purposes today, the case is dismissed. I have a no contact order. So you should probably carry this with you because it'll take about 3 or 4 hours to purge the no contact order from the system. It'll just be on the computer system. So keep this with you, all right? And we'll provide a copy. We'll provide a copy to you, my court officer. Anything else for the record in 2502-354, Ms. Thompson?
No, Your Honor.
Mr. Net.
No, Your Honor.
All right, Ms. Rayler, we'll provide a copy of the order. Thank you for your appearance today. You're all set.
Thank you.
I'll see you. I'll you want to do my last one?
never.
All right. Who are we calling next, Mrs. L?
If we could call Jamar Lackey.
Mr. Lackey is on Zoom. All right. Did you want these called together or separately, Mrs. L?
I believe they can be called together.
All right. All right. So we're on the record in docket 2502-2224 and 2502-2225. Is the people of the state of Michigan versus Jamar Lackey. Appearances for the record, Ms. Thompson.
Laura Thompson for the people.
Mr. Net.
George Annette, APD, on behalf of my client, who was appearing via Zoom this morning.
And sir, you are Jamar Lackey, is that correct?
Yes.
And you can hear me all right, Mr. Lackey?
Yes.
Thank you. This is the time set for a pretrial on these matters, on these two files. Ms. Thompson, how are we proceeding?
We've received the dog licenses for both files, so we move to dismiss for compliance.
Is that a fair statement in your understanding, Mr. Ned?
Yes, Your Honor, compliance was provided, I think, August 24th or 29th. I can't read my own handwriting.
All right, so for compliance purposes, Mr. Lackey, I think they're both on a ticket. Yes. Both of these, including, so these are related to the Duchess, the dog named Duchess and the dog named Ducey are dismissed for compliance purposes at the request of the people. Anything else for the record in 25-02225 or 25-02224, Ms. Thompson?
No, Your Honor.
Mr. Ned?
Yeah, thank you.
Okay, Mr. Lackey, you're all set. Thank you for your appearance today.
Thank you.
Mr. Archer? All right, so we're on the record in docket 25-02123. That is People of the State of Michigan versus Juan Archer. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Izalo, Assistant Prosecutor for the people.
Mr. Ned?
George and APD on behalf of my client, St. Mary.
And sir, you are Juan Manuel Archer, is that correct?
Yes.
Thank you. This is time set for a final pretrial on the matter. Mrs. L, how are we proceeding?
Your Honor, at this time, the people's necessary witnesses have failed to appear. They were subpoenaed for today's date. However, we have not had successful contact with them about this case. We do expect a motion from the defense at this time.
Based on the circumstances, Your Honor, I'm asking the court to dismiss, of course, without prejudice, with a copy to my client.
Right, so we'll have printed out a order of dismissal or nollie pros at the request of the defense. So, Mr. Archer, I'm in possession, thank you, Megan, of the order of acquittal concerning docket 25-02123. At the request of the Mr. Ned, I'm granting the dismissal. This will be granted without prejudice, which means that the people could reissue if they choose to, but realistically today, the case is dismissed. I have a GPS, so you're on GPS right now.
Yes.
So that'll be taken off at the same place you got it. Will be at the sheriff's department. And we'll email the private agency to remove that.
Okay.
So they'll expect you coming. And then there's a no contact order. So yeah, I would carry this acquittal with you because it'll take about 3 or 4 hours to purge from the system. It's all computer oriented. I will sign the dismissal. And you should get a copy for, just to keep on your person. Anything else for the record in 25-02123, Mrs. L?
Not for the people.
Mr.
No,
Annette?
Your Honor.
All right, Mr. Archer, you all set? Thank you for your appearance today.
God, did she do that?
No, man.
Did Destiny Torrance get brought over today?
Not in custody.
Not in custody.
It's not a name.
What's that? We're here on Charles Jackson. Denise Moore. I don't know if you had the opportunity to speak with.
Good morning, Your Honor.
Motion.
All right. I have a motion set aside conviction. Do you have anything on that? So let's see. Got the scheduling order. AG. That was 16. you have anything on the Jackson file? I have the letter that went out to the prosecutor's office and the attorney general.
Do not have anything in our file on that.
And I don't have anything from the AG either. And then, Ms. Moore, are you covering for Ms. Gergwist today?
Yes, good morning, Your Honor.
Good morning.
It's a DP.
It's a set aside conviction. It comes out of Detroit. It's a motion set aside out of a 2016. So I have the letter sent Ms. Moore as of August 12th, but I don't have anything from the Attorney General's office. Usually you get a letter saying that everything's cleaned up, and then the prosecutor here doesn't have anything, but I do have the letter. It's been scheduled for September 9th at 10 a.m. Submit your proof of service to the court verifying you've notified the Ingham County prosecutor. And then I have defendant to submit proof of service prior to hearing.
Did you get
And
the
I
app?
have,
I'm sorry.
yeah, and then I have a blank proof of service. So I have proof of service, but it says I certify that copies of the application and certified record of conviction were served, and then I have blanks as to the prosecuting attorney and the attorney general. So I don't know if the paperwork's complete.
Okay, it looks like we filed it on June 9th. And then we also have a letter from the Attorney General dated June 26, 2025. All of it should have been filed with the court, but if we could get an adjournment, we can make sure.
Yeah, I think you have what we need.
Okay.
So I think that's a great idea. Let's adjourn this. We'll adjourn it out 30 days so you can make sure that we have the same paperwork, because I think you have what we need. You have the proof of service, and then you have the letter from the Attorney General, which would explain why the prosecutor doesn't have anything on this right now. So let's adjourn it out 30 days. Just if we might be in the middle of getting the paperwork, or we may just not have gotten the paperwork. So do you think 30 days would fit in your time frame?
Yes, 30 days is good.
All right. So let's set this. So on today's date, we'll adjourn and let's adjourn to
October 14th at 10.
October 14th at 10 o'clock. And then we will see what paperwork we have. That of course can be attended via Zoom, and that would give you some time, Mrs. L, to check to see if you've got everything you need. Really, what I'm looking for is the prosecutor's office and the letter from the AG.
Okay.
Does that? All right. Anything? So we've adjourned to October 14th at 10 o'clock. Anything else for the record on 1601443, Mrs. L? Miss Moore.
Nothing further. Thank you, Your Honor.
All right. Thank you. You're all set. We'll see you in about a month.
Okay, sounds good. Thank you.
It's Sam, Dad, where's your finger on this?
I think it's Jimmy Brown.
5 is 10 being the highest.
That's Mr. Harris or Mr. Annette.
What time is that, little bro?
I'm gonna mute Jimmy.
Hmm?
But what's the cleaning?
Don't like it at the court, I'll go downstairs and just grab stuff, okay?
I think he's pretty similar. But it sounds like he may be. Oh, yeah. So, yeah, they have a 9:30, I guess. You want this up your head up really hard here. Huh? This, oh, like this? Or up towards this, your face?
All right. Sir, what is your last name? Jimmy?
Jimmy Brown.
All right. Mr. Brown, you're on Zoom in a courtroom, so I would stop eating and we can hear everything you're saying.
Yeah.
Okay, I will go grab his attorney.
Yeah. That might be.
Was you able to hear me, Your Honor?
Yes, Mr. Brown, you should mute right now, okay?
Okay.
Thank you. All right, so we're on the record in docket 25-02336, 25-02337, and 25-02338. That is people of the state of Michigan versus Jimmy Brown. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Ned.
Thank you, Your Honor. George and Ed, APD covering for James Harris on behalf of Jimmy Brown, which is being viewed as a Zoom.
And sir, you are Jimmy Brown, is that correct?
Yes, sir.
All right, you can hear me all right, Mr. Brown?
Yes, I can, Your Honor.
All right, thank you. This is time set for a pretrial on 3 files. Mrs. L, how are we proceeding?
Your Honor, at this time, the typical offer that we would provide for dog license cases being provide us some proper licenses, and we'll go ahead and offer a dismissal. That stands in this case. At this time, it is unclear if Mr. Brown has those licenses or if he'll need more time to do so.
Mr. Ned.
I'm gonna address, I have not spoken with Jimmy Brown, it's Mr. Harris Thomas. Mr. Brown, can you hear me?
Yes, I can.
I just have a yes or no question. That's the only answer I need. Have you came into compliance with what you're totally asked you to do?
No, I have actually 5 dogs.
Oh, that's fine. That's, hold on. Mr.
And
Brown, Mr. Brown,
September.
Mr. Brown,
Yeah, I guess.
hold on. Your Honor, can I get an adjournment, please?
Let's set this for final pretrial. We'll
Absolutely.
set this for final pretrial and then see if Mr. Brown can come into compliance.
But they're compliant with that where,
September 23rd at 8:30.
No, actually, my sister had. So.
September.
So, but anyways, so hopefully he can.
Mr. Brown, I'll give you a call later today regarding other matters as well.
Is it okay that I speak, Your Honor?
I'm advising you not to.
Yeah, you're being advised not to by your attorney. We have adjourned this to September 23rd at 8:30.
Well, this is the reason why I want to speak, because I haven't they giving out free shots for all dogs at the pet store that I go
Is
to.
that
And
after, if that,
yes,
is that
it's
after
on
the
September the 25th. Yes.
All right, so let's get a date after the 25th. That makes sense.
That was the reason I wanted to speak.
And you plan on taking advantage of that clinic for the vaccinations?
Yeah, of course, of course.
All right. So
I'm
we'll
actually
set
from
it for after the
Chicago. I just
25th.
found out, so.
October 14th at 8:30.
Oh yeah, I definitely have their shots and license by then.
All right, so we'll reset this for October 14th at 8:30, and then you can provide the documentation to Mr. Ned, who will forward it to the prosecutor's office concerning those matters. Anything else for the record in 2502-337, 336, or 338, Mrs. L? Mr. Ned. All right, so we've set it after that 23rd date. It'll be set on October 14th. So you can take advantage of that clinic.
Thank you so much, Your Honor.
Thank you.
All right.
We're all set, sir. Have a nice day.
And I will be in compliance when I get back.
All right. Perfect.
All right.
But I gotta put this thing on your finger, monitor.
You want to call something else?
I can hear him.
I can't hear these guys.
On docket 25-00766 says she was arraigned while in the Department of Corrections on August 19th. I'm assuming while she was in the Department of Corrections, she attempted to plead by mail in July.
And then they subsequently arraigned her by video.
Yeah, I mean, she attempted to plead not guilty, so they arraigned her.
And the clerk's office didn't know it.
Yeah, so we didn't writ her out for the pretrial today.
Understood.
And she needs to be writ out. So it's not her fault she's not here. It's probably the court's fault, although what does she need to be writ out of?
We just need to do a video for the pretrial.
Yeah.
I think it can be done by video with the women's correctional.
Huron Valley Correctional Facility. I'll drive to Huron Valley. It's actually a nice county. All right, so I'm going to put it, the defendant failed to appear still in DOC, Huron Valley. So we'll set up a video pretrial. And we're probably looking at it sometime. I've just to set it all up. We can't, in the next 2 weeks, it's not going to get done.
Let's do October 14th at 9 a.m.
October 14th at 9 a.m. It's a retail fraud case. We'll do the pretrial via Zoom on October 14th at 9 a.m. Anything else for the record in 25-00766, Mrs. L?
Not for the people.
Mr. Ned.
Thank you.
All right, thank you. We should be all set. I have all right, Ms. Reinerson, we'll call your case next. You can unmute. We're on the record in docket 25-02368 and 25-02369. That is People of the State of Michigan versus Kathy Reinerson. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Ned. Thank you, Your Honor. George Ned, APD, on behalf of my client Kathy Reinerson, is appearing via Zoom today.
And ma'am, you are Kathy Reinerson?
Yes, Your Honor.
All right. You can hear me all right, Ms. Reinerson?
Yes.
All right. This is the time set for a pretrial on both of these files. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that we're going to be asking for this to be set for a final pretrial, but we are going to be asking for it to be set after that September 25th date so the free clinic can be taken advantage of.
Is that a fair statement, Mr. Ned?
Yes, Your Honor.
So set for final pretrial after the 25th, I believe.
October 14th.
Right, we've reset this for final pretrial for October 14th at 9 o'clock. I'm assuming we can via Zoom is appropriate for final. So Ms. Anderson, I'm going to indicate that Zoom is appropriate for attendance
Okay.
for that final pretrial.
Thank
So
you.
you can attend via Zoom. Yep.
And I am taking them to that clinic. You have to pre-register, and we did that last week, so they will be licensed
Perfect.
that day. Thank you.
All right, and if you provide any of that paperwork to Mr. Ned, he will advance it to the prosecutor's office, okay? In advance, but we've set it for October 14th at 9 o'clock, right, ma'am?
Appreciate that. Thank you.
All right. Anything else for the record in either of these files misses up?
Not for the people.
Mr. Ned.
Yeah, thank you.
All right, Ms. Anderson, we'll see you on that October 14th date.
Thank you.
You're welcome. Sir, on the Google Pixel in the white, could you please identify yourself?
Kenneth Thomas. Your Honor.
Kenneth Thomas. All right. Stand by. You're here for your 10 o'clock, sir?
Yes, sir. Yes, Your Honor.
Did you see how Joshua?
On the cell phone ending in 8300, 8300, could you please identify yourself?
Josh Fowler.
Josh Fowler. And sir, you're here for your 10 o'clock?
Yes, I am, sir.
All right. Stand by. We're going to call your case in just a second.
Just you know.
All right, so we're on the record in docket 2502-516. That is People of the State of Michigan versus Joshua Fowler. Appearances for the record, Mrs. L.
Laura Thompson for the people.
Ms. Thompson. Mr. Annette.
Georgia Annette, APD, on behalf of my client, Mr. Fowler, is appearing via Zoom.
And sir, you are Joshua Fowler, is that correct?
Yes, Your Honor.
And you can hear me all right, Mr. Fowler?
Yes, Your Honor.
This is the time set for pretrial today. Ms. Thompson, how are we proceeding? Have you seen the note? This note from It looks like August 21st, the complaining victim wrote a note.
Oh,
Oh,
yeah.
yes.
All
Yes,
right.
Your Honor.
Sorry.
Just making sure that everybody's got that note. Ms. Thompson, how we proceed?
We'll be setting this for a final pretrial.
Yes, Your Honor, that's correct.
All right, final pretrial is set for,
September 23rd at 8:30.
we'll set for final pretrial on September 23rd at 8:30. That'll be live in person on the 6th floor of City Hall of Lansing on September 23rd at 8:30. Anything else for the record in docket 2502516, Ms. Thompson?
I believe, Mr. Ned, we wanted to put on the record that we are discussing a potential offer in this case as well.
All right, Mr. Ned.
That is correct, Your Honor. It's still negotiations. It's my understanding Mr. Fowler is currently in the one of the special courts in East Lansing. So we're gonna be using some mitigation to see what we can do at the conference trial.
All right. All right. So I'll see everybody on September 23rd at 8:30. Negotiations are ongoing between the parties. Thank you, everybody, for your appearance. You're all set, Mr. Fowler.
Thank you, Your Honor.
And Mr. DeYoung, you are not represented by counsel today, is that correct?
No.
Okay.
Your Honor, if I could just have a moment on that case,
All
we
right.
might actually be able
Yes.
to resolve it.
And did you made financial application to the public defender's office?
You said what? Excuse me?
Have you made financial application to the public defender's office?
No, I haven't.
All right. All right, so let's go on. Friends. And Kendall. All right, so we're on the record in docket 25-02418. That is people of the state of Michigan versus Lee Brandis. Charge schedule for sentencing bond document before you. All right, so Mr. Brandis is not appearances for the record.
Laura Thompson for the people.
Mr. Ned.
George Annette APD covering for James Harris APD of Lee Brandis, who's not here today.
All right, this is the time set for a pretrial in the matter. This was scheduled for 9 o'clock. It is now 10:52. And it would appear Mr. Brandis has failed to appear for the pretrial today. I do not see Mr. Brandis in the Zoom courtroom. There's nobody by that name in the physical courtroom, and nobody's answered by that name in the hallway. It appears that Mr. Brandis has failed to appear. Ms. Thompson, how do you want to proceed?
We're requesting a bench warrant, Your Honor.
Mr. Annette.
Your Honor, I'm not familiar with this file, but there's no prior failures to appear. I asked for 40-hour hold.
There is he never showed, he's supposed to be sentenced in front of me,
Oh.
and he's never appeared for his PSI. So let's use this as a bench warrant just to get him in, and we can figure out how he's going to be sentenced on the PSI, because the probation's never got never got a chance to talk to him. Yeah, let's we'll set this for immediate, for the defendants fail to appear. Yeah, Mr. Brand, this is defendants fail to appear, an immediate bench warrant is issued. He also, on another charge, just like this one, has not been sentenced because he has not appeared for his pre-sentence evaluation by probation. So that's all for the record. 25-02418 will issue an immediate bench warrant for his fail to appear. And then on Miss Little, we're on the record in docket 24-02973. Appearances for the record, Ms. Thompson.
Laura Thompson for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Little, who unfortunately does not seem to be here in person or via Zoom, Your Honor. I will note that she did have a case scheduled on the court's ordinance docket yesterday, for which she also failed to appear. I have not been able to make contact with Ms. Little. I do not have any explanation for the failure to appear.
All right, thank you. This was set for 9 o'clock. It is now 10:54. It would appear the defendant has failed to appear for the landlord tenant for the pretrial. This was, I do not see Kendra Little in the Zoom courtroom or the physical courtroom. Nobody's answering by that name in the hallway. Based on the representations of counsel, it appears that the defendants failed to appear for pretrial. Ms. Little failed to appear yesterday for an ordinance and has a prior failure to appear after a June 24th courtesy reset on this file. Ms. Thompson, how did you want to proceed?
We are requesting a bench warrant, Your Honor.
I would leave the issuing of a bench warrant up to the court's discretion.
This is a driving offense, but with a prior failure to appear in a previous courtesy reset. We're having trouble getting Ms. Little here. So an immediate bench warrant is issued. Anything else for the record in 24-02973, Ms. Thompson?
No, Your Honor.
Mr. Harris?
Nothing in the defense, Your Honor.
Yes. Did you want to go on Mr. McGar?
Yes, Your Honor. I am ready on Mr. McGar.
Jamal McGar. And then is it Adkari?
Yes, Your Honor.
All right, I'm going to swear you in, and you'll translate for us. But let me swear you in. So please state your first name and your last name for the record, ma'am.
Yashoda Adhikari.
Could you spell them both?
YESHODA, Yashoda. Adhikari, ADHIKARI.
Thank you, ma'am. Please raise your right hand. Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications, so if you got under the penalty of perjury?
Yes, sir.
All right, just let me know if I get going a little fast. All right, Ms. Adhikari?
Okay, sir.
All right. So we're on the record in docket 25-02500. And that is People of the State of Michigan versus Jamal McGar. And you can go ahead and interpret.
Okay, as a हामी चाहिँ बिमल मगरको लागि र मिशिगनका मान्छेहरूले दिएको तपाईको लागि तपाईको केसमा आएका छौं 250200 तपाईको केस नम्बर
Appearances for the record, Ms. Thompson.
Laura Thompson for the people.
And then Mr. Harris.
Assistant Public Defender James Harris for Mr. McGar.
And you can go ahead and translate.
Could you please repeat that for me? I wasn't quite sure
Go
what.
ahead. Your name.
Laura Thompson for the people.
Lord Thompson, मान्छे जनताको लागि.
Assistant Public Defender James Harris for Mr. McGar.
Mr. मगरको लागि James Harris. तपाईको लागि
And
बोल्दै.
sir, you are Bimal Magar, is that correct?
तपाईँ बिमल मगर हो?
Yes, sir.
All right, thank you. This is the time set for a pretrial in the matter. Ms. Thompson, how are we proceeding? And we'll let her interpret that.
We've offered Mr.
Well, let's hold off. And so this is the time set for pretrial. Go ahead and translate that for Mr. McGar, and then we'll go get through the offer.
Okay. हामी अब तपाईको लागि प्री-ट्रायल सुरु गर्दैछौँ है.
All right, and then Ms. Thompson, what was the offer made on this file?
We have offered Mr. Bagar plead guilty to domestic violence. And added count 2, that's MCL 750.812, punishable by 93 days and or $500. We would.
All right, let's stop you there.
Sorry.
And then you can, Ms. Adhikari, if you could translate that.
तपाईको लागि आजको प्रस्तावमा के छ भन्देखि हामीले प्रस्ताव गरेको चाहिँ म दोषी हुँ भनेर तपाईले स्वीकार्नु भएको होस् अनि त्यसपछि तपाईले पिएको पदार्थको पनि जाँच भएको थियो जुनमा चाहिँ 750.812 मात्रा भेटेको थियो एमएसएल मा अनि तपाईको लागि $25 को कि कतिको तपाईलाई जरिवाना पनि भनिएको छ र 98 दिनको लागि चाहिँ दिनभित्र यो तिर्नु पर्ने पनि भनिएको हो.
Is there any sensing agreement?
के बुझिएको छ अहिले कुरा?
We will dismiss count 1 for assault and battery. We agreed to 7694A and no upfront jail.
Could you please repeat that for me?
Yeah. We will dismiss count 1 assault and battery. Agree to 7694A and no upfront jail.
So my understanding is.
Could you repeat the last sentence for me? Sorry. 76941 and 48.
No upfront jail.
No front jail.
Upfront jail.
Okay. अनि त्यसपछि के भनेको छ भने तपाईको लागि जो दोष आको छ यो डिसमिस गरिनेछ भनेको यो अब हुने छैन अनि तपाईको लागि जानुपर्ने कारागारमा जानुपर्ने सजाय पनि छैन भनेको छ.
Right, so I'm going to reiterate that just so this would be a plea to the added count 2 of domestic violence, is that correct?
Yes, Your Honor.
With a plea to the domestic violence, count 1, the A and B is to be dismissed, and then there's an agreement to 769 for a status and no upfront jail.
Yes, Your Honor.
Is that your understanding, Mr. Harris?
Yes, Your Honor, that is my understanding.
All right, let's let her translate that, and then we'll go forward.
अनि तपाईलाई के भनिएको छ भने तपाईलाई जो दोष लागेको छ यो मैले गरेको हुँ भन्नु भइसकेपछि तपाईलाई यो केसबाट हटाइने पनि छ र कारागारको लागि चढान पनि हुने छैन भनिएको छ. बुझिएको छ यो कुरा?
All right, and you're not taking the offer today.
My understanding is Mr. McGar, well, would like to take the offer today, Your Honor. My understanding is that it would also involve a dismissal or not proceeding on the contempt hearing that is scheduled today.
So we have a PA 53 violation. That's not a part of the original agreement. Is that part of the?
Yes, Your
All
Honor.
right. All right, and Ms. Adhikari, so they're throwing the PA 50 a PA 53 violation is being put in as part of the mix as part of the no upfront jail and 769 for a status. They will not be proceeding on the PA 53 violation. And then if you could relay that to Mr. McGar.
Okay. तपाईँको जो घरमा घरायसी हिंसा भएको थियो त्यसलाई चाहिँ PA 53 भायोलेसन भनिदो रहेछ अनि त्यसपछि तपाईको आजको दोष स्वीकार्यमा चाहिँ यो तपाईको लागि हुने सजायहरू हुने छैन भन्नुभयो जस्तो छ.
Is that your understanding of the plea offer, Mr. Harris?
Yes, Your Honor.
All right. All right. May I inquire of Mr. McGar of his misdemeanor invasive rights?
Yes, Your Honor.
You may go ahead and translate that to Mr. McGar.
Mr. McGar, तपाईको पालो है उहाँले सोध्नु हुनेछ.
So I'm going to indicate the following jury trial rights that you're waiving in order to plead guilty today. All right, sir?
आज तपाईले मलाई माफी गरिदिनु होला भनेर म दोषी हुँ भनेर भन्न आउनु भएको होइन त?
You have the right to be tried by a jury.
अनि तपाई चाहिँ जुरीले तपाईलाई सोध्ने अधिकार तपाईमा छ भनेर भन्दै हुनुहुन्छ.
You have the right to be presumed innocent till proven guilty.
अनि तपाईको अधिकार छ कि मैले दोष गरेको छैन भनेदेखि दोष छैन र दोष छ भने म दोषी हुँ भनेर अधिकार पनि छ.
You have the right to have the prosecutor prove beyond reasonable doubt that you are guilty.
अनि तपाईसँग अर्को के अधिकार छ भनेदेखि तपाईको प्रोसिक्युटरले बिना कामको दोष लायो भनेदेखि होइन भन्ने अधिकार पनि छ.
You have the right to have witnesses against you appear at trial.
अनि तपाईको विरुद्धमा दिने साक्षीहरू पनि तपाईले ल्याउनको लागि तपाईको साक्षीहरू तपाईले बोलाउन पनि तपाईलाई अधिकार छ.
You have the right to question those witnesses.
अनि तपाईलाई अर्को अधिकार भनेको जो साक्षीहरू छन् उहाँहरूलाई प्रश्न सोध्ने अधिकार पनि छ तपाईसँग.
You were represented today by Attorney James Harris, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan.
अनि तपाईलाई आज चाहिँ जेम्स हेरिसले सहायता गर्दै हुनुहुन्छ बोल्नको लागि र तपाईलाई जो स्टेटको मिशिगनको मान्छेहरूले जो दोष लाउनु भएको छ त्यसमा बोल्नको लागि उहाँलाई सहायता गर्नुहुनेछ.
You have the right to have the court order any witnesses appear in your defense.
अनि तपाईको लागि साक्षी दिने व्यक्तिहरू तपाईले बोलाउनको पनि तपाईलाई अधिकार छ.
You have the right to remain silent during the trial.
अनि तपाईलाई प्रश्न सोधुन्जेलसम्म चुपचाप बस्ने अधिकार पनि छ.
You have the right not to have that silence used against you.
अनि तपाईसँग तपाईलाई कसैले दोष लागेको खण्डमा बोल्ने अधिकार पनि छ.
You have the right to testify at trial if you choose to testify.
अनि यदि जाँच गर्न चाहनुहुन्छ यो सही हो या होइन भनेर भनेदेखि तपाईलाई जाँच गर्ने पनि अधिकार छ.
If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we put on the record.
Could you please repeat that for me?
If your plea is accepted, you'll give up the claim the plea was a result of any promises other than we placed on the record.
Okay. तपाईले आजको प्रस्तावलाई स्वीकार गर्नुभयो भनेदेखि तपाईलाई जे भन्नु भएको छ त्यो भन्दा बाहेकका रिजल्टहरू पनि हुने छैनन्.
You'd also be giving up the claim that this was made as a result of threats and that it is always your choice to plead guilty.
तपाईले के पनि भन्नुहुन्छ भने अगेन आज लिइसकेपछि चाहिँ पछि फेरि भविष्यमा गएर हैन यो हैन भनेर भन्ने अधिकार चाहिँ फेरि गुमाउँदै हुनुहुन्छ.
You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the misdemeanor domestic violence.
अनि आज चाहिँ तपाईले यदि सही मान्नु भयो आजको प्रस्ताव तपाईले स्वीकार्नु भयो भनेदेखि चाहिँ अर्को अधिकार भनेको फेरि आफ्नो लागि म यो होइन है भनेर भन्ने अधिकार पनि गुमाउनु हुनेछ.
You understand that there's an agreement between the people and your attorney that you not receive any upfront jail. If I was going to do something different from that, you'd have the opportunity to withdraw your plea.
अनि अर्को पनि के जान्नुहोस् भने पिपल अफ मिशिगनका मान्छे र तपाईको अटर्नीले तपाईलाई अगाडि कतै पनि जेलमा जानु पर्दैन भनेर पनि भन्नुभएको छ.
Do you understand your rights as they've been indicated to you?
Could you please repeat that for me?
Does Mr. McGar understand the rights that have been indicated to him?
अनि तपाईका अधिकारहरू के हुन् बुझ्नु भएको छ?
Is that a yes, sir?
हो.
I'm going to have you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? And you can translate that.
हात उठाउनुहोस् अनि त्यसपछि दाहिने हात उठाउनुहोस् अनि भन्नुहोस् कि मैले आज बोल्ने सबै कुराहरू सही हुन्, म सत्य बाहेक अरू केही बोल्दिन, सत्य मात्रै बोल्छु भनेर.
Is that a yes, sir?
हो.
All right, I'm going to bring your attention back. You can put your hand down.
हात तल
I'm
झार्नुहोस्.
going to bring your attention back to August 18th, 2025.
Your Honor, just briefly, it's come to the people's attention that Mr. Fuller, I'm sorry, McGar, sorry. Mr. McGar is not eligible for 7694A status. And we just wanted to make defense aware of that before proceeding.
All right. I'm assuming probation would come back with that, but there's still a Killebrew of no upfront jail, but 769-4A status may not be, you may not be eligible for the status.
I understand your.
All right.
Yes. Mrs. Interpreter, if you can simply translate for me. Mr. McGar, we have been advised that the non-public status, special status that was part of the offer, you may not be, well, you are not eligible for. You would still have the no upfront jail as part of the offer, and you would still be referred to probation, but it's unlikely that the case would be a non-public record.
Okay. तपाईलाई के भन्न चाहन्छु भने अघिको प्रस्तावमा हामीले जो भनेका थियौं तपाईलाई जेल चाहिँ जानु पर्दैन र सायद प्रोबेसनमा तपाईलाई पठाइन्छ सकेसम्म तर के पनि भनेका थियौं भनेदेखि पब्लिक रेकर्डमा अर्थात् तपाईको यो केस भएको थियो है भन्ने कुरो चाहिँ सबैलाई भन्नाले यदि जानकारी प्राप्त गर्न खोजेमा पब्लिक रेकर्डमा हुँदैन भनेका थियौं तर त्यो चाहिँ गलत रहेछ पब्लिक रेकर्डमा चाहिँ हुनेछ है भन्नुभयो.
Do you understand that, Mr. McGar?
बुझ्नु भयो त्यो कुरा?
And did you still want to plead guilty today?
र पनि आज प्लिड गिल्टी गर्न चाहनुहुन्छ म दोषी हुँ भन्न चाहनुहुन्छ? Yes.
The answer was yes. So I'm going to bring your attention back to August 18th at 2520 in the city of Lansing. Were you in the city of Lansing at the York Road address on August 18th?
के तपाई अगस्तको 18 तारिखमा सिटी अफ लान्सिङ लान्सिङ शहरमा हुनुहुन्थ्यो?
Okay, that's a yes, sir.
या हो भन्नुभयो?
And are we using the same victim?
Yes, Your Honor. Yeah.
So, and who is Durga Magar to you?
दुर्गा मगर को हो तपाईको?
I believe, Your Honor, he was saying dad.
Okay, your dad. All right. And so you're pleading guilty today to offensively touching Durga Magar, not done in self-defense. What did you do to Durga Magar that was not done in self-defense?
Okay. आज तपाईले के को म दोषी हुँ भनेर स्वीकार्दै हुनुहुन्छ भने मैले चाहिँ दुर्गा मगरलाई चलाएको हुँ अथवा उहाँलाई आक्रमण गरेको हुँ भन्ने कुरा स्वीकार्दै हुनुहुन्छ र यो चाहिँ मैले आफूलाई बचाउन होइन त्यतिकै उहाँलाई हात हालेको हुँ अरु कारणले भन्नु भएको छ भन्नुस् त.
Okay, so what did you do? How did you offensively touch Durga Magar?
भन्नुहोस् त कसरी उहाँलाई चलाउनु भयो अथवा आक्रमण गर्नुभयो?
But so he's making a motion with his hand. Did you hit Mr. McGar?
कुट्नु भएको हो तपाईले हातले यसरी हान्नु भएको हो उहाँलाई?
It looks like it was it's described in the report, Your Honor, I believe, as a swinging motion with his arms. And Mr. McGar seems like he was indicating that he maybe swung his arms out and pushed Mr. Durga McGar.
All right. So did you push Mr. Durga McGar?
तपाईले दुर्गा मगरलाई हुत्ताउनु भयो हो?
And Mr. McGar did not want to be pushed.
अनि मिस्टर मगरले मलाई हुत्ता भन्नु भएको थिएन.
Is that correct, sir?
सही हो?
I think he's indicated yes, that's correct. And this was not done in self-defense. Is that correct? Bimal McGar?
अनि बिमल मगर यो आफूलाई बचाउन गर्नु भएको होइन हैन त?
And the indication is no, this was not done in self-defense.
आफूलाई बचाउन गरेको होइन हैन त?
Anything towards the factual basis, Ms. Thompson?
Yes, Your Honor. Mr. McGar, did you and Durga reside together at this time?
Was it reside together?
Live together, yes, ma'am.
Thank you. तपाईं र दुर्गा मगर त्यो बेलामा सँगै बस्नुहुन्थ्यो हो?
Is that a yes? Okay.
And what was the address where you lived at?
ठेगाना के हो तपाईहरु बस्ने?
हैन म त दिदी भेनाकोमा बस्दै छु.
Currently I'm staying with my sister and brother-in-law.
Where was your address at the time you were staying with your dad?
तपाईं बुवासँग बस्दाखेरि कुन ठेगानामा बस्नुहुन्थ्यो?
2520 York Road.
York Road, okay. And I think the jury instructions indicate that Mr. McGar lived there or once lived there.
Yes,
So-
I believe so, Your Honor.
So I would assume he once lived with his dad. All right. You can go ahead and translate that.
Could you repeat that for me again?
We just clarified that he was living with his dad at the time of the assault.
अनि त्यसो भए हामी यहाँ के क्लियर गराउँदै छौं भने तपाई चाहिँ त्यो बेलामा तपाईको बुवासँगै बस्नुहुन्थ्यो हैन त?
Okay. And he's indicated yes. Thank you, Ms. Thompson. Anything towards the factual basis concerning this plea, Ms. Thompson?
Nothing further, Your Honor.
Mr. Harris?
Nothing really defense, Your Honor.
You can go ahead and translate that, ma'am.
Okay. अरु केही छ तपाईले भन्नु भएको दिएको गवाहीको विरुद्धमा केही छ भनेर सोध्नु भयो उहाँहरु दुवै जनाले छैन भन्नु भयो.
All right. I find the factual basis to be knowing, voluntarily, and accurately made.
अनि मैले यहाँ हेरेको मसँग भएको जानकारी र तपाईले भन्नु भएको अनुसारको जानकारीहरु मैले राखेको छु मसँग.
And so there's a plea to count 2 domestic violence.
अनि यो घरायसी हिंसाको लागि जो दोषीलाई तपाईले क्षमाको लागि जो याचना गर्नु भएको छ त्यो लिएको छ.
And we'll refer to probation.
तपाईलाई हामी प्रोबेसनमा पठाउँदै छौं निगरानीमा.
Probation is 1 floor down all the way to your right. Mr. Harris will show you the way.
अनि प्रोबेसन चाहिँ एक तला मुनि छ दायाँपट्टि तपाई मिस्टर ह्यारिसले तपाईलाई देखाउनु हुनेछ.
I'm assuming we'll need an interpreter for probation purposes. Is that fair?
तपाईलाई प्रोबेसनको लागि पनि सायद इन्टरप्रेटर दिइनेछ त्यो के को त?
So I don't know how they set that up, either there or they'll probably set it up for an appointment.
Yes.
And then have the interpreter there via Zoom, probably.
Yes, that would be my guess, Your Honor.
Okay. So you want to tell Mr. McGar that once he goes to probation on the 5th floor, they'll set up a meeting with an interpreter and the probation agent so that they can discuss this case.
तपाईलाई प्रोबेसन एजेन्टसँगको लागि अपोइन्टमेन्ट बनाइसकेपछि तपाईँ 5औं तल्लामा जानुहुनेछ अनि त्यहाँ प्रोबेसन अफिसरसँग भेटेर तपाईको मिटिङ हुनेछ गफकाफ गर्नुहुनेछ उहाँसँग.
All right, we'll set the sentencing date for
November 4th at 1:30.
All right, so sentencing is set for November 4th at 1:30.
त्यसो भए नोभेम्बर 4 तारिक 1:30 बजेको लागि समय मिलाइएको छ.
And so they'll prepare a report for me and we'll see what options are available to us on November 4th. All right, sir?
अनि त्यो बेला हामी यहीँनेर भेट हुनेछौँ फेरि कोर्टमा अनि त्यसपछि अब तपाईको लागि के कुराहरू छन् अप्सनहरू छन् त्यसमा पनि सल्लाह गर्नेछौँ त्यो दिन है त.
All right, we'll see everybody on November 4th. Anything else for the record on 25-02500, Ms. Thompson?
No, Your Honor.
Mr. Harris?
Nothing from the defense, Your Honor.
All right, Mr. McGard, go down to Mr. Harris will walk you there to the 5th floor and you can set up a time to meet with probation.
हुन्छ त्यसो भए तपाईँ मिस्टर ह्यारिससँग तल जानुस् मिस्टर मगर अनि त्यसपछि प्रोबेसनसँग एउटा अपोइन्टमेन्ट बनाउनु होला गएर.
And we'll need a Nepali interpreter for sentencing.
Thank you, Your Honor. And Mr. Anid has kindly offered to bring him down as I still
All
have a
right,
few cases
perfect.
left.
Right. All right. So Miss Adkahiri or Adhikari, you should be all set. And we've placed down that we do need a interpreter for sentencing.
Thank you. I think the 7C lingo will take care of that. They will let me know.
All right. All right. Thank you for your assistance today. You're all set.
My pleasure. Thank you, sir. You all have a good day.
You too. At 25-02271 and 25 and 24-03213. That is people of the state of Michigan versus Patricia DeMond. We'll handle these. One's a probation violation and one's a final pretrial. So let's go forward. Let's go first on the probation violation. Mrs. L and Mr. Harris, how are we proceeding on the probation violation?
Your Honor, it's my understanding that a couple of the violations will be taken accountability for, pled to, that being violation number 12, the contact with the victim, and I believe violation number 2, leaving the state without permission. The other 2 violations, Your Honor, we are going to be asking to be held on to until the other file is completed, as the violations there are that other file.
All right. Is that a fair statement, Mr. Harris?
Yes, Your Honor, that is a fair statement. The new violations are for conduct that results in, well, the other violations are for conduct that resulted in a new file. And as a bit of a preview, we are going to be requesting that case be set for jury trial with negotiations to complete.
All right, so that's 12 and.
Yes, I believe it should be 12 on the first set of violations and then number 2 on the second set of violations.
12 and 2. All right, Ms. Devon, you understand you have a right to a hearing in this matter. You are represented today by Attorney James Harris, and you would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish to admit to a, let's see, 12, that'd be a non-technical violation of no contact with the victim, and then a leaving the state without permission would be a technical probation violation. It's my understanding It is your wish to admit to both of those allegations. Is that correct?
Yes, Your Honor.
All right. And you've raised your right hand. Do you solemnly swear affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
So let's go to, this is request and summons for PV probation violation submitted by Jody Bayless in violation. It's marked as number 12. That doesn't mean there are 12 violations. It's just the way they mark it. That you had contact with the victim on July 24th, 2025 and July 25th, 2025. Do you admit violating your probation by having contact with the victim?
Yes, Your Honor.
And then do you admit the violation of leaving the state without permission? And that would be on July, oh, you admitted on August 7th. It was for leaving the state on July 12th. Do you admit you left the state without permission of your probation officer?
Yes, Your Honor.
Okay, I find the probation violation be knowing, voluntarily, and accurately made. And Mr. Harris, you've had the opportunity to go through the pre-sentence or through the recommendation with Ms. Demond.
Yes, Your Honor, I have gone over the recommendation with her.
All right. And the people have also seen the recommendation.
We have, Your Honor.
All right. Allocution, Mr. Harris.
Yes, Your Honor. At this point, Ms. Demond is very apologetic and is attempting to take responsibility for those violations. I will note that, as indicated in the violation itself, when the violation for leaving the state happened, and it wasn't something that probation found out that Ms. Demond was trying to hide. It was something Ms. Demond admitted to. She did try and at least own up to what she did. I will note that in the probation packet, there's a copy of some emails that were sent on July, that I believe were received by the probation officer on July 28th regarding the contact on July 24th and July 25th, which Ms. Demond also took the initiative to report to her probation officer, to advise her probation officer what had happened, and to make clear that she wasn't trying to hide anything. She wasn't trying to run from anything. She's been here for every single court date, to the best of my knowledge. She's been, as the prosecutor indicated, she's been here since about 8:30 this morning, trying to get this handled, trying to take responsibility. And to the best of my knowledge, I believe this is the first violation she has had since being on probation, which I believe honestly shows that she's been making some good decisions and that she has been benefiting and learning from probation. I believe it's been, by my notes, I think it's been close to 4 to 5 months that she's been on probation. I'm sorry. Possibly even upwards of 7 months that she's been on probation, according to Ms. Demond, where she has had where, to my knowledge, she has not had any issues. I realize these are rather serious violations, Your Honor. However, I would once again try and note that Ms. Demond is not trying to run. She's not trying to avoid this. She's not trying to she's trying to take responsibility. She's here. She's trying to make sure that she can keep her probation on the level. I will note regarding the recommendation, probation seems willing to continue working with her, as they've indicated they are willing to continue probation. I did speak with her regarding the recommendation of some kind of jail term, as well as the recommendation of revoking the special status, and the recommendation to add a GPS tether and some kind of urinalysis testing. I would ask if the court would perhaps consider, regarding the jail and revocation of the special status, I would ask if the court would consider maybe one or the other, Your Honor. In my opinion, it seems rather harsh to have both in addition to the GPS tether and urinalysis testing. Additionally, Your Honor, if the court is indicating it would like to, it intends to order some kind of jail sentence, I and Mr. Mon through me would like to ask if that could be potentially served on weekends as if she is required to handle a jail sentence that wasn't spent on weekends, that could compromise her job and compromise her ability to take care of kids and provide for them. So I would ask if the court would consider that. And at this point, I would simply throw myself on the mercy of the court on behalf of Ms. Demond and ask if the court would consider ordering, she is willing to agree to the GPS tether and the urinalysis testing. She believes that would help prove that she is not prove that she is not going to violate her probation any further, as she indicated to Ms. Bayless when she was reporting the conduct on 7/24 and 7/25. And regarding the potential revocation of the special status or the jail time, I would simply ask if the court would show mercy to the time she has spent on probation without issue, and for the fact that, simply for the fact that, as I indicated, Ms. Demond has been here. She's never tried to run. She's never tried to avoid taking responsibility for these violations when she knows that she has done wrong. I would simply ask if the court would show her mercy, Your Honor.
Thank you. Allocution before I go to Ms. Demond, from the people.
Your Honor, based on the number of violations that came in front of you today and based on these happening on different dates, different occasions, it isn't very clear to the people that Ms. Demond is taking probation extremely seriously. We do think that the recommendation from probation is fair based on the violations that occurred and the violations that continued to occur. While we do hope that Ms. Demond can continue with probation in the future and not violate, we do believe that probation's recommendation should be followed here. Thank you.
Thank you. Ms. Demond, anything you'd like to say to the court before the court passes the sentence?
I just apologize for going against your orders. I shouldn't have had contact with her, and I should have asked for permission to go out of state. So I just want to apologize, and I understand that I had a lot of violations, but a couple of those violations is for the new case. So I just hope you consider that. And that's it. Thank you.
Thank you. Well, Ms. Demond, you've got a pending with the same victim case, which it's a problem here. You've done no jail on this. This is Kilbrew no jail at your plea, and that was in November. So there've been some time to reflect on whatever's happened. Okay. The new allegations aside, because they're just allegations, I believe the recommendation is fair concerning the activity that you've admitted to. So I'm going to follow the recommendation with some changes. So it is ruled that there have been no previous technical violations. The treatment plan was to go to Waves Women's Group. So that's part of the treatment plan. There's a $461 current balance as of July 28th. You're being continued on probation. So probation went into December. You're placed on probation. I'm going to revoke the 769-4A spouse status because I don't think that's appropriate. We're going to add the GPS tether, but I'm not adding the urinalysis testing at this point in time. But we are adding the GPS tether. And then this is how seriously the court takes the no contact violations. I'm ordering 5 days in jail, okay? And that's to be started immediately, okay? So 5 days in jail today. And I know that there may be consequences for that concerning work and children, those have to be accounted for, okay? So I'm ordering 5 days in jail for the violations. One technical, one non-technical, but it's really the no contact order that becomes a problem, okay? Because that's meant to protect you and protect the person, and that's the violation. And then I've got a pending with the same victim, and that becomes a problem, okay? So 5 days in jail for the 5 days in jail for the PV recommendation, and then I'm following the recommendation except for urinalysis testing. And then I'm assuming that on the 25022271, that's the one being set for final pretrial.
It is, today was the final pretrial, Your Honor. I believe it is being set for jury
Jury
trial
trial.
with negotiations to continue.
All right. Is that a fair statement, Mrs. L?
It is, Your Honor.
All right. So on today's date, we'll set for jury trial on the pending file. And that's set for
September 23rd or October 21st?
let me September 23rd. What is that on the what amount of trials do we have in front on the 23rd? Two. We'll go to October then, I think.
That might be better, Your Honor.
Yeah, just because those two have been waiting on the September docket. So we'll set it for October. What date is that?
I'm sorry, October 21st at 8.
October 21st at 8 o'clock for the pending jury trial. Ms. Damon, you can go with my court officer for the 5 days in jail. Thank you for your appearance statement.
Your Honor, so does that mean I'll be out Saturday morning or is that Sunday?
It should be, let's see, that's Tuesday, Wednesday, Thursday, Friday, Saturday. I would think Sunday morning. That's the 5 days. Is that right? Tuesday, Wednesday, Thursday, Friday,
I
Saturday.
think it might be, I think Saturday might be the 5th day if you count it today.
All right.
but I'm not entirely sure how.
I don't know they count, it'll be Saturday or Sunday morning. All right. All right. Thank you.
Yeah, can you call him? She gotta call my kids and their dad and let them know. You gotta, can you show her how to lift it up? That password, 741. Hold on. Contact. Just call Drew, tell Drew to call my keys. All right.
We have DeYoung, Thomas, and some others.
If we could go on to Young really
All right.
quick.
All right, Mr. DeYoung, we'll call your case. So we're on the record in docket 11040344. That is people of the state of Michigan versus Lorenzo DeYoung. And Mr. DeYoung, you are not represented by counsel today, is that correct?
Correct.
All right. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Bell, Assistant Prosecutor for the People.
All right. And sir, you are Lorenzo DeYoung, is that correct?
Yes, sir.
And you can hear me all right, Mr. DeYoung?
Yes, sir.
All right, thank you. This is the time set for a pretrial in the matter. Mr. Young is not represented by counsel. Mrs. L, how would you like to proceed?
Your Honor, at this time, the people would actually move to submit a nollie in this file. We believe that in the interest of justice, this case can be dismissed.
All right, so we'll get, based on the prosecutor's recommendations, I'm going to dismiss without prejudice, and we'll get it printed out on 11043344. And Mr. DeYoung, I'll explain to you what that means in just a second. All All right, so I'm in possession of the order of nollie pros on the case as signed by the prosecuting official. This means it's dismissed without prejudice, which means that people could reissue if they choose to, but realistically, for our purposes today, the case is dismissed without prejudice, and I'll sign the order accordingly. It looks like there was a no contact order with Maria DeYoung. Just so you know, you're attending via Zoom, so it'll take about 4 hours to purge from the system any no contact orders that continue to be available. Just so you're aware of that, it's going to stay in the system for about 4 hours. All right, Mr. DeYoung?
Okay.
All right, anything else for the record in 1104344? Mrs. L.
Just, Your Honor, that I believe this case is past the statute of limitations, so I'm not sure we can bring it back.
Right. All right. Thank you. You should be all set, Mr. DeYoung. Thank you for your appearance today.
Thank you. Have a nice day.
You too.
Maybe it's up here. Oh, yep. That's probably it. At least not the whole year. The case was for like quite a while. It was issued on 10/6/11 and it didn't get taken out. It didn't get caught on a report. You're not sure how. Okay, I'm so sorry. I know it's about 100.
We do order.
This is just for here, but
Did I do first?
I started them. Okay. I have Word.
Okay.
Or Word, McKinnon, Robbins, Porter, Thomas, Ben.
Panovic.
Yes.
Do you have Schneider and Grego?
Which how were they sent? Thank you so much.
There were applications instead of Snyder.
Oh, we handled one of them.
No, that was.
There was something else.
That was.
Oh, John Schneider, we took off the docket. I have to reset that one. And I don't know what's going on with Greg. I haven't seen anybody for that one.
All right, where are we heading to
I
next?
believe we're ready on David Word.
All right, so we're on the record in docket 24-01215. That's people of the state of Michigan versus David Word. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Isabel, Assistant Prosecutor for the people.
Mr. Ned.
George and at APD, back my client's name. All right.
And sir, you are David Lee Word, is that correct?
Sir.
Thank you. All right, this is the time set for a pretrial in the matter, final pretrial. Mrs. L, how are we proceeding?
Your Honor, the people did have witnesses here today. One witness, an eyewitness to the situation. We did not have the complaining witness here today. However, we have not been able to get in successful contact with her. It is my goal to get in successful contact with her shortly. We are asking for this to be set for a jury trial to not only give us the opportunity to get in contact with her, but also to continue negotiations with defense.
All right, thank you. Is that your understanding, Mr. Ned?
Sure.
All right. We have a, was this set? No, it's only set for the final pretrial.
Right.
All right. So set for jury trial on October 21st at 8 o'clock. All right, so we set for jury trial on October 21st at 8 o'clock. Anything else for the record in 24-01215, Mrs. L?
Not for the people.
Mr. Ned. All right, we'll see you on October 21st. Thank you for your appearance.
Who's the next one? Is that the final pretrial?
Is that yours? Who was the other one?
I've still got Lamar Robinson, I've still got Tammy Banovic.
Okay,
So
Lamar
that kind of-
Robinson on Zoom. or-
Mr. Thomas is on Zoom.
Oh, no, okay. I'm trying to get people out of the.
Yeah, so I got Robinson and Banovic here in person. I got
Okay.
Thomas on Zoom.
Okay.
And then Jimmy Brown's already handled, Jerry Porter's not here.
Okay, let's go on the people here first. So Lamar
Sounds good.
Robinson then.
Lamar Robinson.
Yes, please, Ron.
All right, so we're on the record in docket 25-024-02471. That is people of the state of Michigan versus Lamar Robinson. Appearances for the record, Ms. Thompson.
Laura Thompson for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Lamar Robinson, who is standing to my right, Your Honor.
And sir, you are Lamar Robinson, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a pretrial in the matter. Ms. Thompson, how are we proceeding?
We've offered to Mr. Robinson plead guilty to an amended count 1 of malicious destruction of personal property, less than $200, MCL 750.377A1D. This is a misdemeanor punishable by up to 93 days and/or $500. We've agreed to no upfront jail and restitution to be determined at sentencing.
Yes, Your Honor, that is a correct statement of the offer. I had spoken with Mr. Robinson about the offer, and at this time, he has indicated that he would like to accept that offer, Your Honor. I did briefly explain to him that he would likely be referred to probation, not for any kind of term of probation, but for determining that amount of restitution.
Yeah, restitution will be determined by, if needed, by probation. So I have it as, so I'll reiterate the offer. This would be an amended count 1 of MDOP under $200. Punishable under 750.377A1D. It's a 93-day misdemeanor and/or $500. There's a Killebrew agreement between the attorneys of no upfront jail. So if I was going to sentence jail at sentencing, you have the opportunity to withdraw your plea. Do you understand that, sir?
Yes, Your Honor.
And then restitution will be determined by probation.
Yes, Your Honor.
Is that your understanding, Mr. Harris?
Yes, Your Honor.
All right. May I inquire of Mr. Robinson of his misdemeanor advice of rights?
Yes, Your Honor.
You understand, Mr. Robinson, that you'll be waiving the following jury trial rights if you plead guilty. You'll be waiving the right to be tried by a jury, to be presumed innocent or proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by Attorney James Harris, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give the claim the plea was a result of any promises other than what we've stated on the record, or threats that it was not your choice to plead guilty. You'll also be giving up the right to appeal anything from trial, since you won't be having a trial. You'll be pleading guilty to the malicious destruction of property under $200. Is it still your wish today to plead guilty to the misdemeanor MDOP?
Yes, Your Honor.
Okay. I'm going to raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
I'm going to bring your attention back to August 14th, 2025 at 420 South Grand Avenue in the city of Lansing. Were you at the South Grand Avenue in the city of Lansing on August 14th, 2025?
Yes, Your Honor.
And did you destroy property of the Capital Area Transportation Authority?
Yes, Your Honor.
All right. And the amount of destruction to that bus window was you're pleading to it under $200.
Yes, Your Honor.
Anything towards a factual basis, Ms. Thompson?
No, Your Honor.
Mr. Harris?
Not for the defense, Your Honor.
All right, I find the factual basis to be knowing, voluntarily, and accurately made, and will refer to probation. Specifically for restitution, but also they'll provide a report to me. So we'll see what options are available to us at sentencing. All right, sir?
Okay, thank you.
And the sentencing date will be
November 4th
November 4th
at 2.
at 2:30. So one floor down to the 5th floor, all the way to your right is the probation department. And they'll either meet with you now or set up a meeting. And they'll do a report for me, and we'll see what's available to us on November 4th at 2:30.
Thank you.
Anything else for the record in 25-02-471, Ms. Thompson?
No, Your Honor.
Mr. Harris?
Not from the defense, Your Honor.
All right, Mr. Robinson, we'll see you on that November date.
Have a nice day.
You too.
And she said, oh, there's a way to verify information. So, I
No,
got.
that's fair.
I don't know.
Chips can be so out of date. sometimes.
I was just gonna say, I like how sometimes I get to see it slowly radicalized against it. So, yeah.
All right, who's next, Ms. Azell?
If we could go on Tammy Banovic.
And all right. All right, so we're on the record in 25-02299. That is people of the state of Michigan versus Tammy Banovic. Will the parties please introduce themselves to the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Tammy Banovic, who is standing to my right.
And ma'am, you are Tammy Banovic, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a pretrial in the matter. Mrs. L, how we proceed?
Your Honor, it's my understanding we're going to be leaving this set for a final pretrial.
That is my understanding as well, Your Honor. I've spoken with Ms. Banovic about the case, and at this time, we would be leaving on for final pretrial as negotiations continue.
All right, we'll set for final pretrial on
September 23rd at 8:30.
December 23rd at 8:30. That'll be live on the 6th floor City Hall of Lansing, just like today, just like we're here today. Anything else for the record in 25-02299, Mrs. L?
Not for people.
Mr. Harris.
Not for the defense, Your Honor.
You're all set, Ms. Banovic. Thank you for your appearance.
Okay.
Ian. Porter and Thomas.
Yes, I believe Mr. Need has McKeon and is currently discussing with that case.
Okay.
And then Porter is a failure to appear, and Thomas, I am ready on it. I'm ready on both Porter and Thomas.
All right, let's go on Thomas. Mr. Thomas has been.
Dismiss the dog license, set the rest for the final.
All right, so we're on the record, and Mr. Thomas, you can unmute.
Yep, I'm here, Your Honor.
All right, so we're on the record in docket 25-02239, 25-02240, and 25-02241. That is people of the state of Michigan versus Kenneth Thomas. Appearances for the record, Ms. Thompson.
Laura Thompson for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Kenneth Thomas, who is joining via Zoom, Your Honor.
And sir, you are Kenneth Thomas, is that correct? Sir, you are Kenneth Thomas?
His device might be frozen, Your Honor.
Yeah.
I don't know. To connect.
He's been here for like,
Yeah.
oh, let's see if he rejoins us.
We're
Or-
case.
Isn't that about,
I can get in touch with him afterwards.
Is, what were we doing on the case?
Dismiss the dog license for compliance and then set the
Okay.
other two for final pretrial.
Okay,
Yes,
so
Your Honor, that's
you could
correct.
talk to him about that.
And then I believe though we would, the defense would also be requesting a motion date regarding a motion that I believe was submitted. And I believe Monday.
Yeah, I don't think we have that yet. All right, so, and Mr. Thomas. Okay,
Yes,
so,
yes,
sir.
Yes, Your
So,
Honor.
sir, you are Kenneth Thomas?
Yes, Your Honor.
All right, thank you. This time set for a pretrial in the matter. Ms. Thompson, how are we proceeding today?
You're going to dismiss the dog license and the 02239 file
239.
to compliance. And then the remaining two files will be set for final pretrial.
All right, so
That is,
dismiss
correct
for
statement of facts, Your Honor.
compliance. Dismiss for compliance on 25-02239. And then the other two to be set for final pretrial. Is that a fair statement, Mr. Harris?
Yes, Your Honor, that is a fair statement.
So we'll get a final pretrial date of
September 23rd at 8:30.
all right, Mr. Thomas, we've set this for September 23rd at 8:30 for final pretrial. That'll be live in person on the 6th floor City Hall of Lansing, unless I hear differently from the parties. Anything else for the record at 25-02240 or 25-02241, Ms. Thompson?
No, Your Honor.
Mr. Harris?
Just to confirm, Your Honor, since the court indicated it had not received the motion yet, would it be setting the motion date when it receives?
Most likely we'd set it when we get it, and
Understood.
yeah, so that'll be set when we get it. We'll probably set it on a Tuesday, probably sometime before September 23rd.
Understood. If the court prefers, my original request was simply going to be asking for the motion date to be set probably same time as the final.
All right, that's then we'll most likely set it at the same time.
Thank you, Your Honor.
All right.
Mr. Harry, since it's your motion, though, you will be required to send the notices.
Understood. I will get in touch with my office about that.
All
Thank
right.
you.
So Mr. Thomas, you're all set. Thank you for your appearance today.
Your Honor, I didn't hear it. Some of that I did not hear. It like the video paused, so I didn't hear everything for
All
the
right.
date.
So one of the files was dismissed, and we've set the other final pretrial for September 23rd at 8:30.
Okay.
All right.
Thanks, Your Honor.
And if you have any additional questions, you should talk to your lawyer, Mr. Harris. All right.
Yes, Your Honor.
All right. Thank you, sir. You're all set.
And Mr. Thomas, I can get in touch with you later this week regarding the remaining charges. All right.
Yes, sir. Thank you.
All right. Did we want to go on McKeon?
Yes, Your Honor, we are ready on that.
All right. So we're on the record in docket 24-03206, 25-01047. That is People of the State of Michigan versus Jennifer McKeon. Will the parties please introduce themselves to the record? Ms. Thompson.
Laura Thompson for the people.
Mr. Annette.
George and at APD on behalf of my client staying to my right.
And ma'am, you are Jennifer McKeon, is that correct? Thank you. This is time set for a pretrial in the matter. Ms. Thompson, how are we proceeding?
We're moving to dismiss both files. We've been informed Ms. McKeon no longer has the dog.
And that's a fair statement, Mr. Annette, that's your understanding?
Yes, Your Honor, my client wants to thank the prosecution for the understanding of their situation that she had going on.
All right, this involves, so you're, Ms. McKeon, you are no longer responsible or in control of Dottie. The dog was returned. Okay. All right. For compliance measures, both 2403-206 and 2501-047 are dismissed without prejudice, which is really just a default. People could reissue if they choose to, not realistic in this case. So the case is dismissed. All right, ma'am? All right, thank you. So that's McKeon. Then we have Porter.
Yes,
Is
we
it
have
no-show?
the last one.
So nobody showed up on Borrego.
Nope.
It was a big nope.
Nope.
All right, so we're on the record in docket 25-01397. That is people of the state of Michigan versus Jerry Porter. Appearances for the, I promise I will show up. That makes my day, okay? That right there made my day. When they write down a quote from the defense on a no-show, I promise I will show up. I don't, even the magistrate set bond on this one, okay? Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Porter, who, despite the indication in the court's file, unfortunately does not seem to be here.
No.
I have not been able to make contact with him, as the number he has on file with us was listed as either disconnected or no longer in service. I do not have an explanation for why he failed to appear, despite promising to do so. I would leave it up to the court's discretion whether whether it wishes to order a immediate bench warrant on this case.
All right, thank you. Mr. Porter's pretrial was scheduled for 10 o'clock. It is now 11:59. It would appear the defendants failed to appear for the pretrial. I do not see Mr. Porter in the Zoom courtroom or physical courtroom. Nobody answers by that name in the hallway. This would be Mr. Porter's 1, 2, 3 third failed to appear. Mrs. L, how would you like to proceed?
Your Honor, at this time, we would ask that bench warrant be issued in this case.
Yeah, but for the prior 3 failed to appears, I think it would kill me if I didn't issue an immediate bench warrant. So for failed to appear, an immediate bench warrant is issued. Once in a while, we don't, because we're not sure of the prior bench warrants. The other bench warrants are all in my writing, so we just want to get Mr. Porter here. Anything else for the record in 25-01397, Mrs. L?
Not for the people.
Mr. Harris?
Nothing from the defense, Your
All
Honor.
right. I think that, I don't see anybody here, so I think that's the morning docket.
I believe so.
Not bad, not bad. I don't know, do you want to reset Borrego or do you want, because we didn't get anybody up here.
Is there no tea letter?
It's the same as the last.
No, I know you have that.
There's no AG letter.
Mrs. L, it's just on the record, be like, but Mrs. L, he promised. Don't you trust a man who promised?
It must not have been a pinky promise, okay? He must have just flipped that, or he crossed his toes.
Just
Yeah.
to write that down, it just was perfect timing. You guys are like, I liked it. I actually.
Oh, that is absolutely going in my case now.
Yeah, I mean, you've got to. I mean, you can't time it better than that.
Yeah, let's confirm he doesn't have any medication.
Is this just going back to stop working? Okay. I can go and just pick up that and grab some morning.
There's. and then
Promise I'll show up.
everybody promised. I promise I'll show up.
That regardless of what happened in the courtroom.
I remanded Mr. Brandis and said, see me. Because we got to get a presence on him.
Well, when I was getting the docket ready this morning and I was doing my part of it, I was like, I could have swore I just typed.
You
a
did.
no-show
You did.
Thing, and I have to send that this morning. And then I was like, oh my God, I did. I am not hallucinating.
All right. And then that's the second mullet file.
Yes. Could you hand this to Susie Price and tell her it's the other file on the shelf? Yes.
That's the duplicate file.
Sorry.
Is there any other files or no?
That should be the
No.
end of it.
All right. We moved some cases. We said some cases, but we moved some cases. I'm gonna take this back with me. We have a couple sentencing this afternoon. 1, 2. Oshie and Rogers. Davis. And then all that civil stuff. All right. I'm going to see if Lola wants out.
Something.
Eat something.
Oh, my muscles started to lock up.
We got a break.
I know, which helps tremendously. It was
Yeah.
just.
I think it does. Go walk around a bit. Everything settled down the last hour.
Yeah. Nice to hear myself think.
All right, I will see you at 1:30.
Yeah, I figured, you're right. Yeah. Yeah, exactly.
Or good afternoon.
Hello, good afternoon. I'm just here for that sentencing motion.
Why you are here.
Yeah, just for the Lewis and Moshi sentencing.
Sounds good.
Like, for sentencing, I don't entirely know how much appearance I'm expecting. It's like Rogers, yeah, has 2 no-show reports now, and she shows up.
Did you see Wendy's email?
Oh, was that about Rogers? I hadn't had a chance to check that. I meant to
Yeah.
check that over the lunch break, but
There's a transcript if you scroll down. She pretty much says like, please give me another chance to show up.
well, you got a chance to show up. It's just if you do, you're likely going to jail.
Yeah, so who knows?
I mean, hey, if you show up, that might potentially give me some argument to make that, hey, even knowing what was likely to happen, she still showed up.
Yeah.
Right, yeah, and then Janisha Davis.
Yeah.
On that one, well, originally that was the one where it was kind of adjourned to see if there were any the mental health issues. That was the one where Flores called us into chambers.
What, do you do anything on that?
I spoke with her, I briefly went over it, she indicated that she was previously in a mental hospital in 2023 and is still, like, because of I think it was a DV case where she was a complaining witness.
Yeah.
And it has been diagnosed with BPD and PTSD as a result. She's got some triggers that that Deja minutes. Yeah. That occasionally her PTSD, those things get triggered and she kind of acts out, which she apologizes for, but she's trying to manage them, but still has the occasional episode. And then
I don't think any of that should impact sentencing though.
yeah.
Do you disagree?
I would say maybe it slightly mitigates because it could explain, 1, the actions that led to the underlying case, and then 2, her kind of explosion a little bit with Jody.
Yeah, it sure does.
Where she's sitting here going, hey, I've got these issues, I'm trying to deal with this, and Jody's like, hey, no, you have to stay on the screen, you can't blah, blah, blah. Like, my argument would be, hey, maybe that was what affected it, but also, I'm not sure how much we can really resolve today, considering I did get in touch with her yesterday, and she indicated that she is currently in the hospital for pneumonia. And I went, well, and I was talking to her going, well, given that you're currently facing one I recall from the, what I recall from the recommendation was essentially a straight jail sentence. And all that, I was thinking going, I think it's decently likely that you and Slash or the court are probably gonna go and say, hey, we want some proof that she's in the hospital.
I mean, it's
And
probably
all
more the
that.
court. I mean,
And I go, okay, so I told her that, I said, hey, the court and potentially the prosecutor may want just some indication.
have you called the hospital to just check and see if they'll tell you if she's there?
Didn't indicate which hospital, it just said, I'm in the hospital, I had pneumonia, I can't risk making everyone sick. I've been here since yesterday afternoon. And all that. And I went, can you give me something from the hospital or some information about the hospital or a doctor, like a doctor's note or something? And she went, okay, I told my nurse and she said someone will come and they will also contact my doctor's office and I can get that information to you. And to which I said, hey, in the event I don't get that information, I realize this may be asking a lot, but I'm going to put the Zoom information here. If you can't get anything to me, it would be great if you could just hop on Zoom just to be like, look, I'm in the hospital.
Or look, I'm not running away from my
Yeah.
sentencing, I'm communicating.
So
Yeah,
I'm like,
okay,
so I told her that and that's the last I heard.
all right, we'll put it all on the record. I'll probably leave it to judge's discretion on what to do there. I never feel right issuing a bench warrant when somebody's in the hospital, so.
Oh, yeah.
Or like asking for you know what I mean.
Yeah, so those are the two things I actually have. And then there's 4 PDAs. So far, one of which is here. I realize you probably don't care about
I
this.
don't care about those until they become hearings, and then I scramble to figure out what the hearings are. Are you on the probation violation hearing today?
Nope, that is George. Or,
Magoo.
yes, Mr.
was
Magoo's the one to report. Except I know that's Mr. Megorian's one to report you.
No, it was close enough. That was good.
I know, but Mr. Magoo isn't actually here. Can't remember what he's
Mr.
from.
Oh, I don't remember what.
Yeah, for some reason, I'm trying to remember what it's from, and all my brain is bringing up is Mr. Blobby.
Oh, I am so happy.
Yeah,
That's not it.
yeah, it's Mr. Blobby. Horribly awful, terrifying mascot character for children in the UK.
Mr. Magoo.
There you go, Mr. Magoo. That's Mr. Magoo, but it's kind of fun calling him Mr. Magoo.
I know.
George is on that. At least from what I heard from George, it doesn't necessarily sound like it's going to hear him, but I'll leave that up. I'm aware of I'm aware that there's also an absconding in there.
Oh, is there?
I think so.
Oh, I gotta scroll to the bottom of the report.
Here's George here,
Do I have questions, or did I just-
Reynolds can answer what is going to happen.
Okay.
Found information.
Are we running that violation hearing?
Talking about the guys not here today?
Are you sure he's not gonna show?
Yeah.
Okay,
He's
cool.
not- Are you sure he's not in custody?
Talking about my guy Magoo?
Yeah.
He couldn't make it. But he'll be on Zoom to address the issue.
Why couldn't he come in then?
Okay, so no, I talked to like last week a few times about this case. He's supposed to be here today at a time. He said he reached out to the court 24 hours in advance. I told him reach out to your probation officer, your attorney. He didn't necessarily have my number. He didn't know who Keith Watson was, which I mean that makes sense. And I called him today and he's like, yeah, I couldn't find a ride and I'm not gonna risk driving. His license is suspended. So he can be on room, he's gonna ask for an adjournment if he gets a warning, so we're
Hello,
gonna
Roger.
solve it tomorrow or sometime this week. He wasn't a big responsibility today. If the court wants to let us run today, that's fine. I saw the recommendation. He's not gonna run.
Oh, I was like, I mean, okay, so,
So,
my feeling is he's gonna have his probation revoked.
yeah,
So
He's got-
he's gotta be here.
yeah. He's been on probation for 10 months. He's been checking every month on time. It's absconding. Month 10, Sumter told the probation officer, hey, you have finished pass. He's like, what the heck? And he's like, it's 2, 3, whatever month pass.
Okay,
And then he got scared and then absconded for 2 years. He was 2 months away. It would have been done if he just showed up. Well, besides the pass, I mean, probation could have been extended.
yeah,
My thoughts were Sumter could have violated him early on, 10 months ago, 9 months ago, 8 months ago, 7 months ago, whatever.
and he did, well, yeah, he did.
Wow.
There are 3 violations. 2 of them are from January, or from March, but they happened in
In
January
January.
and February, and then you have the absconding, which was reported after, back in September.
So.
So it's
of this
sounding
year.
like he absconded after this one
That's not, yeah.
was issued. So I don't really like that timeline.
He must have not, something must have happened because I don't, my understanding, and I don't know.
Well, it sounds like he got scared of this violation and then ran. And are you not scared that's what's gonna happen here?
No.
Because that's kind of
Yeah.
what's being indicated
Yeah.
here. I mean,
I'd like to know what happened with that March violation, because he said month 10 is when he was informed of the not finishing pass. The
so
MRT's probation. You have to show up on January, so he didn't with the violations in March for what he missed in January and February. That makes sense. He still,
yeah, 'cause probably the failure to enroll, he was probably waiting to see if he was gonna do it. So he probably brought both of these violations at once.
Yeah.
To save people time and,
well, yeah, I mean, probation be wrong, that's fine. His biggest thing is whatever the jail sentence says, he wants it on weekends.
you know, that's not gonna happen, right? I've never seen Judge do that.
After I saw that, I don't think so either.
Okay.
Just a matter of how much jail time I think he's gonna do. He's just concerned about, he has a job, he lives on Lake Huron.
I mean, I'm concerned, okay, but you know, like Huron's an hour and a half from here.
Yeah, you know more than, I don't know much.
I'm from that area.
Yeah, we plan on playing it, we're not contesting anything. It's a matter of what the sanctions are.
Well, he's gotta be here is the issue.
Yeah.
Because if he's gonna serve jail time, he's gotta be here.
Right.
I don't think Judge is gonna like that he's not here and
sure.
jail was suggested. It's gonna look really bad for him.
Yeah, and he said if there's a warrant, I'm turning myself in. Like, it's just a matter of.
How is he gonna turn himself in if he can't even get to court?
He had a ride schedule that did not work as planned. Which, when you're indigent, I mean, it makes sense. Again, could be a lie, could be, I mean, anything could be a lie. He told me, and we had contact, he was adamant that he was gonna be here today. We talked on, I think, on Thursday and Friday, talked in depth about this. I talked to Joe Sumter on, I think, on Thursday or Friday, asking him about what his thoughts were about this guy and, 10 months probation, and he said, from my understanding, yeah, my understanding is some, who knows what, and he violated him on 10. The one you just showed me that was back in March, I thought that was at the same time. I have been looking and now it's not. I wonder if he didn't have a bench warrant out there. I can almost assure that he never told me that I had a warrant for March.
See?
It was more like he would notify month 10 and they got scared.
Yeah,
and
I mean,
And he said he's on.
I mean, I'm gonna,
Whatever happens, happens. He should
why
have
did
been
I
here.
have him on? I have him as an arraignment today too.
Oh, so that's another thing. He is scheduled for, that's why I was confused on my D. It said arraignment and hearing. So I'm not sure which is which.
Okay,
So
so he was probably already arraigned on the one from March. Is my
hopefully,
understanding,
yeah.
and then today he's being arraigned on the one from, yeah.
that makes sense.
So let's see. 'cause
I guess the
that would've
question, when
been-
did the warrant enter for the March one? Yeah.
Yeah, I'm looking. That would be on base.
Yeah. Sometimes. Staying out the way, defense. Yeah. That's right. Defense off, man. That's a good way to put it. Give me a line.
Yeah, I don't see anything. Looks like the case might have fallen through the cracks on our system.
And he was reporting if you look at the PD docs, he did, from my understanding, again, I can read things differently, I've never seen this. Towards that, I've never seen, you'll see what I'm talking about here in a minute. Keep going. So that right there, I've never seen that. But it looks like he was reporting almost every month, based on the way I looked at it.
Yeah, but then it's gone. Come on.
Yeah, month 10 is my understanding.
And again, why, you said he got scared.
He got scared because he knew he was going to jail because nobody's gonna finish a whatever month class in a matter of 2 months.
And they would have just extended his probation.
When you're not educated, that's what you like.
But that's why you call him. Talk to your probation agent.
And he tried, if you look at the notes, he tried telling him about the working test that and kept trying to, he did, should have done more, but he did not. But at the same time, and I like Joseph, he's a friend of mine. Joseph, I could have maybe did a little more, too, like, hey, violating him early on. For not enrolling in PATS, because if you knew that was 6 to 8, whatever month class, should have been done early on, instead of wait till I was like, put him on
Yeah, but
probation.
I'm wondering how many excuses your client gave to him about not signing up for the class.
So his reasoning is he tried to enroll and kept trying to enroll, but I forgot what it was, and again, a lot of
You're not
explanation. Explanation of why he can enroll in MRT. I think MRT is part of PATS.
All right, so we're on the record in docket 24-01676. That is People of the State of Michigan versus Janisha Davis. Will the parties please introduce themselves to the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the People.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Janisha Davis. She is joining via Zoom for this sentencing, Your Honor. I understand the sentencing was in person. She did contact me yesterday advising that she was current, that since I believe Sunday afternoon, she had been hospitalized for pneumonia and would be likely unable to make it to court today. I indicated to her that if she could, I imagine the court would want either some proof from documentation from the hospital about that stay. She emailed me before court indicating that she had trouble getting that and had joined the Zoom meeting just to show the court that she's not trying to run or avoid this court hearing. She's simply in the hospital, unable to be here for, well, her own safety today, Your Honor.
All right, and ma'am, you are Janisha Davis or Janisha Davis. You'll have to unmute.
Yes, I am.
All right, so this is time set for sentencing. I do have a pre-sentence report. Actually, this is not for sentencing, is it?
Yeah, I believe it should be for sentencing, Your Honor.
Of sentencing, oh, for probation matter. Is that right? I don't know. I have a judgment of sentence here.
Well, Your Honor, I believe we were previously here for sentencing a bit ago, and then the court adjourned sentencing for some questions and concerns regarding Ms. Davis's, I believe, mental health. So this was, and that was a matter, I believe, back on August 5th. And then parties went into chambers and discussed, and then the court indicated it was going to be resetting sentencing for today.
That is my understanding as well, Your Honor.
I have CJO's adjourned sentencing, date of sentencing September 9th, but I didn't make any notes concerning any meetings we had. Just have a restitution amount, and then I have, and then you've seen the judgment of sentence. That does not, it does not go along with the pre-sentence recommendation. So let's go off the record and approach. All right. So, so I've had the opportunity to talk to counsel, and we looked at some of this. This was adjourned for some matters to look into. It appears that this would be an in-person sentencing would be the better move here. Ms. Davis, you're presently presently have a conflict. Obviously, you're in the hospital. So, do you have any sense of Mr. Harris, do you have any sense of when she'll be out or Miss Davis will be available?
I do not, Your Honor. I would leave that up to Ms.
Miss Davis, how long are they keeping you there?
I have pneumonia from COVID, but they told me I should be released tomorrow if my breathing is better.
So let's do, what do you think? What do you think of 30 days?
I think that's fine.
30 days out. I
Yeah.
mean, that gives some time for her to get healthy and to come in and we can kind of address some of the issues that were previously talked about. I'd rather do that in person than do it via Zoom. Also, I'd assume Mr. Harris would rather do that in person than be here via Zoom. All right, so Ms. Davis, we're going to adjourn the sentencing for obvious reasons. Yeah, we can't sentence you while you're on Zoom, but this is confirmation while you're on Zoom. So so that worked. But let's adjourn this out, and then we can revisit. I think we have all the information we need. So I'm going to adjourn the sentencing. And we will do, this will be live in person on the 6th floor for
October 14th at 2:30.
October 14th at 2:30. So Miss Davis, we've adjourned this to October 14th at 2:30. If you have any questions, you can contact your attorney, Mr. Harris. All right, ma'am?
Thank you.
You're welcome. All right, any questions concerning the adjournment of sentencing? Mrs. L.
Not for the people.
Mr. Harris.
Not from the defense, Your Honor.
All right, we'll adjourn to that date. We're all set on that file. Ms. Davis, you're all set. Thank you for your appearance.
Thank you.
All right. Moon is, I don't have Macoon has ever been arraigned.
I think he was arraigned on Saturday, Judge.
As he failed to appear.
He wasn't that.
I have April 1st, probation violation arraignment. It was set for 1:30, called at 2:27. DFTA on arraignment. And then I have August 29th, confirmed address, but I don't know that he'd ever been arraigned on it. Whose writing is that? So did she arraign him on the
What was the date?
August 29th?
Yes, she arraigned him. And then probation scheduled it for today.
All right. Right, and that's the one file we have, because it's set for violation of probation and arraignment
Yeah,
on
I
the
don't-
same file.
I don't know why. 'Cause on August 29th, Mary Kelly did arraign him.
September 3rd. Because there were new allegations as of September 3rd. And he was arraigned on August 1st. I don't think he'd be arraigned on the September 3rd allegations.
That's my understanding.
Okay.
Yeah, he said that he failed to appear April 1st.
Yeah, April 1st was a fail to appear. There was arraigned on the PV on August 29th, but then we have new allegations as of September 3rd. So I think I've got to arraign him on the new allegations.
What are the new allegations?
They're right here.
Yeah, this is not making any sense. This is when he printed it. He actually entered them into the system on 8/29. And it looks like he got printed on 9/3.
She didn't leave any notes to that effect.
I know, she doesn't.
That's a problem.
Yeah, all I can tell you is, yeah,
So,
I think to be safe, really.
yeah, I think we're gonna. So, Mr. Magoon, you can unmute. Christopher Magoon, you can unmute. I guess it doesn't matter if he
Well,
doesn't.
he must have been arraigned just because the public defender's office has filed an appearance.
Can you hear me, Your Honor?
All right, I can now, Mr. Magoon. So we're on the record in 24-00159. That is People of the State of Michigan versus Christopher Magoon. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Bell, Assistant Prosecutor for the People.
Mr. Ned.
Thank you, Your Honor. George Annette, on behalf of my clients appearing via Zoom today.
And sir, you are Christopher Magoon, is that correct?
Yes, Your Honor.
Mr. Annette, have you had the opportunity to speak with Mr. Magoon concerning some of these allegations?
Yes.
And so I'm trying to figure out if he's been arraigned on these new allegations that were dated September 3rd, but may have been printed out previously. Failed to report to probation officer for more than 60 days and absconded probation. That is the allegation. I don't have a prior allegation. Are those, I do have a probation violation arraignment that he failed to appear on April 1st. And that is the April 1st, that's the prior failed to appear. And then there's this a weird arraignment of a confirmed address and a PR bond. So I guess my question is, what was he arraigned on?
Great question, Your Honor.
Mr. Magoon, do you remember what you were arraigned on?
On what date, Your Honor?
You would have been arraigned on August 29th.
That was for the probation violation, it said. I'm just unsure of which one. I was never told which one.
Yeah, I'm not sure either because I don't have any notes. I just have that the PR bond was issued and that you were arraigned on a failed to report to probation officer for more than 60 days and an absconded probation. But I don't know. I don't have, and that's dated from September 3rd. That would be, those allegations would be made the same date of arraignment.
They probably issued him the same.
Yeah,
They
I'm
probably
confused.
told him that he was in custody on the original.
PPR bond.
They probably let
So
probation know that he had already had a warrant for probation violation and they added the additional charges.
let's address this all live, okay? Let's have Mr. Magoon here. And so Mr. Magoon, I'm gonna treat this as an arraignment. I'm gonna rearraign you to make sure you understand the nature of the allegations and brought against you. And then we're gonna set it for hearing and that'll be live on the 6th floor City Hall. And then Mr. Ned will be here and that's your attorney for this hearing. And you can discuss the matter live with him, all right?
Okay, yes, Your Honor.
I think that would clear things up because I'm not sure the nature of the arraignment, but we'll do an arraignment. So you have a right to a hearing in this matter within 14 days of today's date, or you can waive that depending, since we're rearraigning you. The allegation are from September 3rd, 2025. It was signed by Joe Sumter on that date. And this is for a request and summons for probation violation. It is alleged that you failed to report to your probation officer more than 60 days and has absconded from probation. And that would be to Joe Sumter, and that was dated September 3rd, 2025. Mr. Magoon, do you understand the nature of the allegations that have been brought against you?
Yes, Your Honor, I understand.
All right. We have George Sinet is your assigned attorney in the matter. And what we're going to do is set this for hearing. that'll be a live hearing now that you've been arraigned. And you can come and talk to Mr. Annette, and we can see if anything can be worked out. If not, that'll be the hearing date. All right, sir?
Yes, Your Honor.
All right. We'll set it for hearing date on
September 25th at 9.
September 25th at 9 o'clock for hearing date. I know Mr. Annette will be here on that date. So it's a Thursday. So Mrs. L will be here also.
Yeah, can we approach for a brief
Wait,
second?
no, I don't.
No.
Just talk to me.
So I thought you said yes. Be adjourned depending on timing.
Depending, yep. So, all right, so Mr. Magoon, we've reset this.
Your Honor, that's, sorry to interrupt. He lives an hour and a half away, so for him to come and, that's gonna be an issue.
Like he'd have to leave like at 7.
And if it gets I mean, he doesn't drive, so that's gonna be another problem. The reason why he wasn't here in person today, because he couldn't find his transportation canceled. He tried to reach out 24 hours in advance, to my understanding, when I spoke with him earlier. I see this being, I mean, I guess it's just.
I guess that's the only date we have, because then he'd have to waive the hearing date.
Well, it still had the problem of getting here regardless of what we said.
Regardless. Yeah, well, we could set it for the afternoon, but it would be a later date. So did you want to waive because we can set it for a Tuesday afternoon, but it's probably going to be, it's not going to be within 14 days.
Okay.
Does he want to waive the timeline, or it's going to be hard if he's on Zoom? But that's your prerogative, not mine.
Can we approach for a brief moment?
Sure.
I just want to at least just give.
Yeah, maybe.
All right, Mr. Magoon, your attorney will be calling you to talk about this. We have to set it within 14 days, a hearing date. That's waivable, but you should talk to your lawyer about that.
What date would that be?
So the date we're setting for September 23rd at 9 o'clock.
8:30.
At 8:30.
If we were to waive that.
If you were to waive that, then the date would be, it'd be in the afternoon on a Tuesday that followed.
The following Tuesday?
I don't know.
It wouldn't be the following Tuesday.
Yeah, so it'd be the 23rd?
The 23rd is 2 weeks, so that's what I'm trying to do.
Yeah.
If we don't do it that day, it would have to get adjourned to October 14th.
So we're trying to do the 23rd. We'd get it within 14 days. It would probably be, that would be the 7th, right?
October
14th. So it'd probably be the 14th if he waived the 14-day notice.
I'm gonna call him right
I can
now.
wait. I can waive it and make it
Mr. Magoon,
easier
listen,
for me to.
I'm gonna give you a call right now. Pick up your
Yeah,
phone.
Mr. Annette is going to call you, and
Oh,
then you can we'll
okay.
put it on the record. Okay.
Okay. I might have, there.
All right. On the Samsung, could you please identify yourself, sir?
Anthony Anglin.
Anthony Anglin.
Yes, Your Honor.
All right. And so I can do Mr. Anglin, that's the arraignment.
Your Honor, Miss Deja Mitz is also here for the arraignment. She's already had an intake done by Mr. Neat.
All right. All right, so we're on the record in docket 1805291. That is People of the State of Michigan versus Anthony Anglin. Appearances for the record. Sir, you are Anthony Anglin, is that correct?
Yes, I am, Your Honor.
All right,
by
thank
the way,
you.
I have received the wrong information as far as the Zoom ID, so I was in another judge's waiting room. I had a contact.
All right, I'm going to read you the nature of the arraignments of the allegations that are made against you, and then we'll set this for hearing, April. So these go back to May. So I have, let's see, May. I have in May, from probation officer Jody Bayless, May 15, 2025, defendant resides in Henderson, Kentucky, located on the Indiana and Kentucky state border. Defendant permitted to reside in Kentucky and travel only between Indiana, Michigan, and Kentucky. I don't know if that's an actual allegation.
That was the amendment.
Okay, I guess you can call it what you want, but that's what's written on it.
Oh, there should be an allegation from August.
All right, so that was the initial. I don't know who wrote that. On August 11th, 2025, it is alleged that you failed to submit to testing per Involvement Incorporated in Kentucky. Defendant has failed to test since June 27th, 2025, and on violation 16, and that doesn't mean there's 16 violations. That's just how they number it. You failed to report to scheduled substance abuse education course through ABR on August 9th, 2025, and it indicates from Jody Bayless that you were no call, no show on that date. Mr. Anglin, do you understand the nature of the allegations that have been brought against you by the probation office?
Yes, Your Honor.
Okay. You have a right to a hearing in this matter. You have a right to counsel. You've already made application, I believe. Is that correct?
I do not believe he's spoken with him.
All right.
No, Your Honor, I tried to reach out to him last week. I also emailed him. I want to verify his number and email.
All right. So, Mr. Anglin, we have a couple of public defenders here. We're going to verify your confirmation address. So in order to make application on this, which I think you should have, and then we'll set it for hearing. All right.
Okay, Your Honor. All right. I'm just a little confused about a couple of things.
You should tell all this to your lawyer. All right.
Okay.
All right. So Mr. Ned, were you looking to confirm any information?
Mr. Hayes is gonna jump on.
Okay.
And confirm, because we have a phone number, an email, and an address. I did call, the number seemed disconnected to me, and I also sent the email, so Mr. Hayes is gonna verify the information so we can conduct it.
All right.
I've updated my number with my probation officer.
Were you gonna update?
Oh, I was going to hop on Zoom and do
All
that
right.
afterwards. along with the
Okay,
date.
all right. So let's set it for hearing, and if you stay on, Mr. Anglin, we'll place you in a room with Mr. Harris from the Public Defender's Office, and you can trade any information you might need. All right, so I'm gonna indicate that the probation violation was arraigned on the new, I'm believing these are August 11th allegations. And we will set for
September 23rd at 8:30.
set for September 23rd at 8:30. And then Mr. Anglin, I'm going to place you in a room with Mr. Harris, and you can but that's when it's set for, the hearing is set for September 23rd at 8:30.
So one more concern, Honor, he lives in Kentucky. Does he have to be in person?
Yes, he has to be in person.
Did you hear that, Mr. Anglin?
Your Honor. May I speak, Your Honor?
You can speak all you want, Mr. Anglin, but part of the problem is you're on probation in Kentucky, and the indication is that you're not doing what's required on probation, and now we got a problem.
No, I'm most definitely doing what I'm supposed. I'm most definitely doing what I'm supposed to be doing.
Then we're gonna have a hearing on it. Because that's not what the allegation would indicate. Now, if your attorney can contact the probation agent and find out if this can be resolved, we may not need we may not need the hearing date. But right now, the allegation is that you outside in Kentucky have failed to submit to testing, and you failed to report to scheduled substance abuse education. So that's the hearing we have, and you've got to have a hearing under Michigan law within 14 days. So we've set it for September 23rd at 8:30. Did you still want to talk to him, Mr. Ned?
Okay. Mr. Harris is gonna do the intake. And I'll talk to him afterwards. Now, is it possible if this does get resolved with probation and they indicate to the courts that hearings?
As long as I hear from probation that the hearings is fine, we don't have to have the hearing.
Understood.
All right. All right. So, Mr.
Your Honor.
So, yes.
One of the allegations that I just noticed was the substance abuse. The substance abuse class.
We're gonna work it out with your probation officer. It's not gonna matter for today's purpose.
Yeah.
We'll work it out.
Anything you indicate to me, you probably shouldn't say, and that's the allegation at this time. Yeah, the allegation is that you did not attend when requested. So that's why we've set it for hearing date. I'm going to place you in a room 1 with Mr. Harris from the Public Defender's Office, and you can make sure you have the contact information correct. All right, Mr. Anglin?
Yes, Your Honor. I was just trying to highlight the fact that my PO said that she was going to remove the allegation of the substance abuse because.
Okay, she is not.
Wow.
She has not removed it. So until I hear differently from her, that's not a thing. All right, so I will put you in room 1, and when Mr. Harris, when you join, I'll also put you in room 1.
Thank you, Your Honor.
Okay. And then do you want to go on Mr. Magoon?
Or Deja Mintz?
We have Ms. Moshi brought up.
Yeah, we have Moshi brought up.
We just have to finish.
I didn't know if you'd met with Mr. Magoon.
Oh, yeah, we did. He's waving.
Okay, he's waving the.
He
All
would
right.
like the October 14th date.
All right, let's go ahead and put that on the record now. And then we'll get to Moshi. And that's your client, Mr. Palmer.
That's correct, Judge.
All right, so Mr. Magoon, you can unmute.
Yes, Your Honor.
It's my understanding that you're going to be waiving. You've talked to your attorney, Mr. Ned, and you'll be waiving the hearing date within 14 days, so we can set it outside that time frame. Is that correct?
Yes, Your Honor, that's correct.
All right, and Mr. Ned, you'll be waiving on behalf of your client. Is that correct?
Yes, Your Honor, until for October 14th at
October 14th at
1:30.
1:30.
We'll be there. Thank you.
All right, so Mr. Ragoon, we've set it for October 14th at 1:30. That'll be live in person on the 6th floor. Thank you for your appearance today. You should be all set.
Thank you very much, Your Honor. I appreciate it.
All right. And then Mr. Harry's, we're going to put in one.
Can I just have him move over here?
Yeah, you can.
Just motion to go over here. See.
Well, let's go on Mr. That will go on Mr. Motion.
Thank you, Judge.
Thank you, Mr. Palmer. All right, so we're on the record in docket 25-00727. That is People of the State of Michigan versus Louis Moshi. Appearances for the record, Mrs. O.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Palmer.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Moshi, the gentleman who's standing to my right.
And sir, you are Louis Adele Moshi, is that correct?
Correct.
All right.
Yes, Your Honor.
Thank you. This is the time set for sentencing today. Do we have any other restitution on, I don't have any restitution on the pre-sentence or the judgment of sentence. Is there any restitution that that you're aware of, Ms. Azell?
No, Your Honor.
All right. Mr. Palmer, have you had the opportunity to go through the pre-sentence report?
Yes, Your Honor. I have reviewed the PSI with my client. I will note, Judge, that it's a little bit dated at this point. I think it's still accurate, so I don't have any updates or changes to it, but I do want to just say that it was prepared
on June 10th.
It was prepared in preparation for sentencing. It was supposed to happen a couple of months ago. Mr. Moshi failed to appear. He's now here.
All right.
I do have an update with regards to the jail credit when the court's ready for that.
All right. All right. And what is the update for the jail credit?
Sure, Judge. By my calculation, he has been in custody for, I think it should be 40 days. The basis for that would be that, as indicated in the PSI, he was originally picked up on March 8th of this year, then arraigned and released March 9th. So there's 2 days there. And then he was arrested again August 3rd of this year on the warrant when he failed to appear for sentencing. And then he's been in custody until today. So August 3rd to today being 38 days by my calculation. So a total of 40, I think, is what it should be. I don't know if people have an objection to that, but I think that's what it is.
All right. You do whatever math you need. But we understand it's all right. With that understanding, Mr. Palmer, are there any other corrections to the pre-sentence report?
I can't remember if it's reflected in here. I do want to make sure that the court has an updated telephone number for him, but I don't know that it's actually contained in the PSI.
I have 763-9251.
That's correct. Then yes, the court has
it.
I have 37.
Close enough.
I had a different phone number for him, but the correct one is 763-9251, area code 517. The address on High Street still remains correct.
Okay, that I have that phone number on High Street.
And I want to make sure I'm clear, judges, so the court's aware, if the court decides to go probation route today, the phone number, the 9251 phone number belongs to my client's girlfriend, Samantha. My client himself does not have a phone number.
Okay. All right, with that understanding, and I had that note, a similar note in the file. Allocution, Mr. Palmer.
Thank you, Your Honor. Mr. Moshi's now been in custody 40 days. He served almost half of the maximum penalty in this matter. I have reviewed the PSI with Mr. Moshi. I do think that the PSI is fair and appropriate in both what it contains and its recommendations. I would ask that the court consider releasing Mr. Moshi and putting him on a term of probation. I do think that there are a couple of things that probation could assist Mr. Moshi with. That is some potential therapy and also some assistance, possible assistance with job hunting. Mr. Moshi has been unemployed for about 2 years. The last job he held was roughly 2 years ago. That was he worked for a duct cleaning. He did duct cleaning for a furnace HVAC type business. He does have limited criminal history. This was a somewhat bizarre case, and factually, in some ways, factually, I'm proud of Mr. Moshi. And the reason I say that is that he was in a disagreement with
his girlfriend at the time, and rather than staying and allowing that argument to turn physical, as the court sees so often in so many cases that come before the court, both the felony and misdemeanor level, he walked away. So that's a good thing. And I'm glad he did that. I'm glad he didn't engage in assaultive behavior. But what he ended up doing is going, and he's pled to this, so I can talk about this. What he ended up doing is going to an abandoned house and trying to spend the night. And so he got caught in this abandoned house. And you know, I think it's fair to say that Mr. Moshe's intentions were good, his actions were bad, probably in that particular case. I would ask that the court consider placing Mr. Moshe on a term of probation and releasing him today. I'm not aware of anything else that holds him in custody. He's, as I said, he's done about 40 days. So I certainly think he's learned his lesson in terms of his responsibility to the court and complying with the court's orders and probation. I know that the last 38 days has not been fun or comfortable for Mr. Moshe sitting in the county jail. So I'd ask that the court release him and place him on term.
All right. Thank you. Mrs. L, anything you'd like to say on the case before the court passes sentence and here's from Mr. Moshe?
No, Your Honor, we would leave this to your discretion. Thank you.
All right. Mr. Moshe, is there anything you'd like to say to the court before the court passes sentence?
It's been horrible because I miss my son. I'm so sorry. It's been so hard. I don't mean to cry, but it's hard when you love somebody so much.
All right.
It's just so faulty because I didn't mean to do anything. I didn't hurt nobody. I'm a good fucking person.
All right. All right. So this was for a guilty plea found on April 25th, 2025. It is the order of the court that the defendant spend 37 days in jail. Credit is given for 30 days, 37 days previously served. We will do a fines of $100, costs of $100, crime victims' rights fee of $75, state minimum cost fee of $50. I'm not placing Mr. Moshe on probation just because I just don't see. I don't see that. I don't recognize Mr. Moshe. You've served 37 days on this.
Yeah.
The last thing you need is me involved in your life for 6 more months.
Yeah.
All right. So let's leave it at that.
I'd love to do probation.
All right. I think 37 days is fine on this. Okay. We'll do $200 fines and costs and $125 for a grand total of $325 for fines and costs. We'll give 90 days for the payment on that.
Understood. And Mr. Moshe, just so we're clear, all right, you're going to be released today from the jail. You're not going to be on probation, so you don't have any responsibility to Judge Flores. What you do have to do is you have to either pay your fines and costs in 90 days, or you have to show up here to the court and set up a payment plan. If you can't afford to do that, okay? Because the problem you're going to have is if you don't do one of those two things, then Judge Flores has to write a warrant, then they come pick you up, and then you have to sit in jail again until they can figure out when you're going to pay. So don't do that, right? Make sure you do one of the two things. If you don't have the money, that's okay. He's not going to put you in jail. I hope I'm not speaking.
You're fine.
He's not going to put you in jail for not having money. All right. But you have to arrange with the court a way to pay, even if it's $5 or $10 a month. Got it? Okay.
So as long as there's an arrangement made on the 6th floor, you can pay whatever you can afford for your finances, as long as they know that they've got something coming in, and then we'll give you 90 days. I think that's December 9th, and then after that date, just continue with keeping them updated. Okay, that'll keep you out of the show cause cycle, and you want to stay out of the show cause cycle because that's when we start asking for warrants for non-payment. And you can stay out of that. All right.
Yes, Your Honor.
All right. So we'll set a sentencing date. It's set for $325 within 90 days. That'll be December 9th. This is all looks really pretty. And then the jail time is 37 days in jail and credit for 37 days. I'm going, that's the end of your sentence. The final cost will be December 9th. You can pay online, in person, or at the counter by December. As long as it's all paid by December, you can set up your own plan.
Yes, Your Honor.
And I will set all right, Mr. Moshi, we're all set. Good luck to you, okay, sir?
Thank you, Your Honor. Thank you, Judge.
Thank you, Mr. Palmer. Mrs. Zell, where are we heading now?
If we could go on Deja Mitz.
All right, Ms. Mitz. All right, so we're on the record in docket 21-01767. That is I have an arraignment for Ms. Mitz. Is that right?
Sure.
All right. And ma'am, so on 21-01767, ma'am, you are Deja Mitz, is that correct?
Correct.
All right, thank you. This is the time set for a probation violation arraignment. And you've had the opportunity to speak with Mr. Ned?
Yes.
All right. So I can give you the allegations. We can set this for hearing.
Sure.
Okay. The allegation that is brought against you by probation agent Joseph Sumter on August 22nd, 2025, Mr. Sumter made the following allegations. Looks like there were 3 of them. In violation one, failed to report to probation as directed on August 21st, 2025. That would be 3. So that's the first probation violation type. Technical probation violation is a failed to report. In violation 14, there aren't 14 violations. It's just how we number them. Per AbraHealth, your analysis was positive for methamphetamine and for buprenorphine and for cocaine. So that's violation 14 was tested positive. And then on violation 15, which is the 3rd violation, per AbraHealth failed to submit to your analysis as directed on July 22nd and August 7th. So do you understand that the nature of the probation violations that have been alleged against you, ma'am? You have a right to hearing this matter. You have the right to counsel. You've already spoken with George Sined, and I believe you had the public defender's office on the underlying charge for the MDOP. All right, so we're going to set this for hearing. We'll set it within 14 days. And then at that time, that'll be the hearing date. And we'll see what either it can be worked out or we'll go to hearing on that date. So the hearing date is?
September 23rd at 8:30.
Okay, September 23rd at 8:30. That'll be live in person on the 6th floor of City Hall of Lansing. And we'll have a hearing on that date on September 23rd. I can't tell. So you should get your notice of hearing from my court officer for that September 23rd date, all right? All right, anything else for the record in 21-01-767, Mr. Annette?
Yeah, thank you.
All right, Ms. Mitz, you're all set. Thank you for your appearance.
I just have to wait for it to print.
And I have Moore and Rogers left. Oh, and Delamarter.
I believe we are ready on Ms. Rogers. I have not seen Ms. Moore or Mr. Delmarter.
I am not seeing. either of them.
Delmarter's got like 2 FTAs already.
I'm here.
All right.
Miss Moore's here.
Wonderful.
Ayana Moore's here.
Oh, Ayana Moore.
Handle that intake.
Yeah, I'm here.
That's in arraignment. All right. So Ms. Moore, we'll call your case. Well, we got the other one here. That is Ms. Rogers.
Yes, Your Honor, it's Ms. Rogers.
All right. And so we're on the record in docket 21-01694. And I have no PSI done for Ms. Rogers.
Yes, Your Honor. And I can go into that on the record.
All right. So this is the time set for sentencing. And there was no probation report done because of the fail to appear for the PSI on the underlying charge. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Rogers, who is standing to my right, Your Honor.
And ma'am, you are Kyla Rogers, is that correct?
Yes.
Thank you. This is the time set for a sentencing in the matter. I don't have any PSI, so they're just recommending straight jail time at this time. Mr. Harris, what did you want to do towards an explanation? Because I don't have anything to work with.
Yes, and honestly, in all honesty, Your Honor, Ms. Rogers does apologize. She indicated that she has been going through a lot lately. She's currently working she has got employed, is currently working 2 jobs actually, and has experienced, I believe she indicated, was 2 deaths in her family relatively recently. She indicated that was a large part of the reason why she essentially, for lack of a better term, lost track of things and did not get the PSI done with Mr. Hanna. My understanding is she did try and contact Mr. Hanna. I think it was yesterday about getting some sort of report done. However, by that point, it was simply too late. At this point, I will note, Your Honor, she is willing and able to try and get that interview done. She also has support of a family member here who has indicated that she would be willing to help make sure Ms. Rogers stays on track to get any future appointments done. If the court is not willing to consider one last chance of getting the PSI done, I will also note, Your Honor, that when I spoke with Ms. Rogers, she did indicate that she is currently on probation in the 55th District Court for a similar charge, I believe, retail fraud charge. In that case, she is currently dropping, I believe she indicated, was twice a week with Adam. She's set for, I believe, 3 months of probation on that case. My understanding is that there is a violation hearing scheduled. However, she has not been sentenced on that, and the recommendation for that is not termination. It is, I believe, per the notes from Mr. Howie at my office, Nicholas Howie, who represents her on that violation, the indication was continue probation and extend it 3 months. I believe there may also be an indication of upwards of 5 days in jail on that violation. However, Ms. Rogers has indicated that she has gotten things turned, and not to start allocuting on another case that's not even assigned to this court, but she has indicated that she has managed to turn things around and she has been doing a lot better with her probation. And the moment she had these issues with her case over in 55th, she immediately contacted her probation officer over there to try and take responsibility for that error and own up to the mistake so that she can be a better, healthier person. And this is partially moving into allocution, Your Honor. But at this point, I would ask if the court would consider having the probation in 55th, since it is for a similar charge and likely would have similar rehabilitative goals to this case. I would ask if the court would consider having her essentially having her probation here be non-reporting probation with simply enlisted as follow all terms of her probation in 55th. 50, I understand that the probation department may not be willing to work with her. Well, the probation department here may not be willing to work with her because of the failures to appear,
No,
but
he
it's,
said he would.
well, my understanding from her is that Mr. Hanna would still be willing to work with her. And it sounds like the probation department over at the 55th District Court is willing to work with her to help her become a healthier, better person so that these kind of cases don't happen again, Your Honor. I did discuss with her that if the court did have her probation here mirror her probation at 55th, that would mean that any future violations or issues she has with her probation in 55th would be considered a violation of her probation here as well. She indicates that she is more than willing to do that, to show the court that she's not going to have any further violations and that she can become a better, healthier person so that something like this won't happen again. If the court is unwilling to have any term of probation here mirror the term of probation she has with 55th, then I would simply try and note that this is a non-violent, non-assaultive offense where to my knowledge, there is no restitution that was needed as all the items were recovered. Miss Rogers does apologize for the actions she took, and she is trying to become a better person. She's trying to learn better ways of being out in society so that these kind of charges don't happen again, Your Honor. I would simply request that the court would consider, if the court is not willing to consider allowing her probation in 55th to mirror this, that the court sentence her to fines and costs on this charge and simply show some mercy, Your Honor. If the court is interested in, well, if the court is considering setting a jail sentence on this charge, I would ask if the court would consider allowing her to sentence that on weekends or consider a relatively on the lower end of potential jail time, given that this was a non-violent, non-assaultive charge where there is no restitution that is outstanding, and where any kind of lengthier jail sentence could potentially interrupt or otherwise affect her ability to properly participate in the probation she has over at 55th, who does seem to be willing to work with her at this point, Your Honor. So I would simply request that the court consider, in summary, I would simply request that the court consider either mirroring her 55th probation to this case and having it be non-reporting with following all the terms of her probation in 55th, or consider a fines and cost sentence, Your Honor. Thank you.
Thank you. Ms. Zell, any comment before I hear from Ms. Rogers?
Your Honor, the people are of the stance that probation is unlikely to succeed in this case. There were multiple failures to appear for the PSI. There are 2 violations already out in 55th for her probation out there. Your Honor, without a PSI in this case from our probation unit, we would be against probation on this file. Thank you.
All right, thank you. Ms. Rogers, I simply don't know anything about you, okay? I don't know. I know that the PSI was scheduled for June 6th. and then rescheduled for July 2nd. You missed both of those dates. So I'm going to remand you right now, okay? And I'm going to remand you with the understanding that once the PSI is done, you can PPR, okay? I just need to know more about you. It's either that or I sentence you to a jail sentence.
Sir, I go to work at 2 o'clock.
Not today, you don't.
Can you?
Okay, not today, you
You
don't.
know how long
No.
it's gonna be for my PSI?
I have no idea, okay? It could be tomorrow, it could be the next day. I don't know what their schedule is. What I do know is it's either that or send you to a straight jail sentence based on this charge and not knowing anything about you except your CCH, which I have in front of me. It would probably be about 60 to 70 days. You have a 2018 felonious assault. I mean, you have a 2018 felonious assault. This is not this is a lower retail fraud misdemeanor crime, but your history is not good. Okay.
Sir, I listen to me.
Yeah, no, you listen to me. Okay. I understand this is a hardship. I don't have my hands are tied. I either need to know more about you from the pre-sentence report, or I just sentence you to 60 days and write you off.
My daughter will make sure I get to my.
That's not going to work today. That's not going to work today. You have the choice, man. You have the choice to do a straight 60-day sentence, or you can wait and get a pre-sentence done by probation, who's already indicated they don't want to work with you because they've never met with you.
I went down there and I tried to meet with them.
Which would you prefer, ma'am?
I'd rather go in and get my PSI.
Okay, so I'm going to remand you until your PSI is complete. And then you are PR'd after your PSI is complete. Okay, so I'm going to set PR bond at $1,000 after PSI is complete. And then we'll have a PSI done. And then if Mr. Harris tells me everything that you're going to be on probation in 55th, I can confirm it, and that's good. I mean, all that, we just don't know any of that because the probation officer.
I have my paperwork.
That you never met with probation.
No, I'm talking about from 55th.
Yeah, that I need to hear it from your probation officer here. Okay, I need it in writing from your probation officer so he can indicate to me, look, this is the same as 55th, and we can do the same. But I don't have none of that because a pre-sentence investigation was never done twice in this matter. All right. So you've chosen, we're going to remand you for the pre-sentence report. You'll be PR bonded after the pre-sentence report. And Mr. Hanna, we'll see you either tomorrow, the next day. I would think in the next couple of days, but I'm not sure. I don't know what his schedule is. All right.
So I'll probably be there for like a week.
I don't know, ma'am. I really don't know. I can't guarantee any time. What I can guarantee you is we're going to get a PSI done so that we would have something to sentence you on. All right. All right. So you're remanded for the PSI, and we'll set the sentencing date, I would think, for a month, 30 days.
I think that would be fine.
That should work, Your Honor.
Yeah, 30 days out. So we'll set the sentencing date for.
Can I get work release?
Until the PSI is done, you can't get anything, man. Okay. So it's set for sentencing on
10/14.
10/14.
2:30.
2:30. All right. So we've set the sentencing for October 14th at 2:30. I would think the PSI would be done way before that. So we'd all have a copy of that. Good luck to you, Ms. Rogers. All right. And then we have.
The remainder are arraignment.
I have more.
There's Yana Moore and Mark Delamarter, to my
Okay.
knowledge, and neither of them are here.
No,
Ms. Moore is.
Yes, I'm here.
Mr. Delamarter is not here.
All right, let's go on. More. And then we can start. So we're on the record in docket 23-00366. That's people of the state of Michigan versus Oyana Moore. Appearances for the record, Miss Moore.
Yes, I'm here, Oyana Moore.
All right, this is the time set for a probation violation arraignment. I'm going to read to you the charges that have been alleged, and then I'm going to set this for a hearing. You were represented by the public defender's office on this underlying charge. Is that correct?
Yes.
Okay, so Ms. Moore, so what you're gonna have to do is file an application. I don't know. You can probably call the public defender's office to file an application, so you'll be represented by counsel unless at that hearing. All right, ma'am?
Okay, when's the next hearing?
I'm gonna tell you in just a second. Let me tell you the allegations.
Okay.
The allegations were filed by Brendan Hanna on August 6, 2025, that you failed to make payment towards restitution, and therefore that's a technical probation violation. You have the right to counsel. The public defender's office is here and has other cases, but you can make application for the public defender to represent you in this file. Do you plan on doing that, Ms. Moore? I think it's a good idea.
Yes, I plan on, my family's gonna give me some money to put on this bill, so I'll be down there tomorrow. So do you know where I can be directed to fill out an application once I come to City Hall tomorrow? Because I do not know what for or how to proceed with that.
The public defender's office is not in City Hall, but I can give you a phone number, and then you can indicate that number is 517-679-2979. That's 517-679-2979. If you're paying towards a restitution, you can come and pay it at the counter or through your probation agent, I would think, but usually at the counter. They'll have a full accounting at the counter. Right now, the current balance is $1,817. So that is on the current balance. I'm going to set this for hearing, and we'll set for hearing on
September 23rd at 8:30.
September 23rd. So it'll be set for a hearing on September 23rd at 8:30. That'll be live in person on the 6th floor of City Hall of Lansing. And I would contact the public defender's office to make application, make that a priority because you have the hearing date. So save that hearing date for their purposes for September 23rd at 8:30. All right, ma'am?
Your Honor,
All right, and then you said the number was 679.
I have a public defender that's willing to meet with you if we put you in a room with him. Ma'am, would you be available to meet with the public defender to make financial application?
Yeah.
All right. So Mr. Harris, once you join us, so Miss Moore, I'm gonna place you in a room. You're the phone number, I believe.
Yes, sir.
Yeah. So I'm gonna place you in a room, and Mr. Harris from the public defender's office will be in the same room, and you can make application to him. He can answer any questions you have, and then we'll set it for September 23rd at 8:30. All right, so I'm gonna move you to room 1, and then I'll put Mr. Harris in the same room when you're done.
All right.
And then you can leave, you'll be all set.
All right, thank you so
Mr.
much.
Harris,
sir.
thank you.
Your Honor, did you need me for anything else?
I think we have one arraignment left. We have a no-show. Delamarter's a no-show.
And I will see you all on Thursday.
See you.
All right, we'll see you. Okay, that's one. Then we have Delamarter. On the record in 24-03514. That is People of the State of Michigan versus Mark Delamarter. This was scheduled for 1:30. It is now 3:07. I do not see a, I see Mr. Harris. I do not see a Mark Delamarter in the Zoom courtroom or physical courtroom. Nobody answers that by that name in the hallway. It would appear the defendant has failed to appear for the probation violation arraignment, and a bench warrant is issued for the fail to appear. That's all for the record in docket 24-03514.
Judge, I'll be right back. I just have to go take this remand slip. I didn't have one filled out.
All right. I think I only have one regular file.
Huh?
I think I only have one regular file.
You need one electronic file?
Yes.
Oh, okay. I was
One
like,
elect-
uh-oh.
The rest are, yeah, the rest are
Actuals?
regular files. That's what I meant to say.
Okay, you scared me. I was like, where did we put them?
Yeah, they're right here. All right, let me pull that up. And then-
Others and after case numbers.
Hold on. That's right.
Yeah. Normally.
All right. Oh, look at that. All right, Mr. Smith, we can call your first case, and that is 1602848. No, what about 1601688? 18. 86. All right, Mr. Smith. So we're on the record in 1601686. That is Lafque versus Jordan Mata. Appearances for the record, Mr. Smith.
For plaintiff Lafque, Tim Smith, P48259.
All right. There's only one person on the blue M10 LL Pro. Could you please identify yourself? You'll have to unmute. On the blue M10L PRO, could you please unmute and identify yourself? Is there a representative of Jordan Mata in the Zoom courtroom? Is there a representative of Jordan Mata in the physical courtroom? Hearing no representative of Jordan Mata, Mr. Smith, it would appear this was scheduled for 2:30. It is now 3:11. It would appear that the defendant has failed to appear for the show cause. We previously met on June 17th, where the defendant failed to appear for discovery and a show cause was set. Mr. Smith, how would you like to proceed?
The record should reflect that after his failure to appear on June 17th, he did call my office on the 25th. I completed the Q&A part of the examination, but did send him a letter reminding him that there were certain documents that were responsive to the court's subpoena. He has not returned or forwarded those documents to my office. So in light of not only the failure to appear on the 17th, but also in trying to work with him off the record, failure to produce any of the documents. At this point, I think since I did do the Q&A off the record, let's do a second show cause with 9-day mailing as we did before to give him one more chance before moving to warrant.
All right. So we'll set it for a second show cause hearing, and I'll await the order to follow with the 9-day notice. Is that correct, Mr. Smith?
Yes, Your Honor. We'll prepare and submit.
All right. Anything else for the record in 1601686, Mr. Smith?
Nothing, Your Honor. Thank you.
All right. We'll wait the order to follow. Thank you for your appearance on that file today. Let me see if on the BLUM, sir, can you unmute that device and tell me what case you're here on? Yeah, I can see I can't, you're under mute, so you're gonna have to unmute. Yeah, I still can't hear you. Yeah, you're still under mute, sir. So I just want to make sure you're not bench warranted for your non-appearance. So I want to make sure I know who you are. You're still on mute. There you go. You're
Okay.
off mute. What's your name, sir?
My name is Don McCray.
All right, that's the next case. So I'm glad we were able to. All right, so we're on the record in docket 1602842. That is Lafkew versus Don McCray. Appearances for the record, Mr. Smith.
On behalf of plaintiff Lafkew, Tim Smith, P 48259.
And sir, you are Don McCray, is that correct?
Yes, sir.
All right, thank you. This is the time set for a motion to show cause. We were here on July 15th and defendant failed to appear for a discovery. This case was called at 3 o'clock. It was called at 3:40, was scheduled for 3 o'clock. So the request for show cause was granted. Mr. Smith, it appears that Mr. McCray has now appeared. Did you want to meet with him to continue the discovery proceeding, or how did you want to proceed?
If we can get a breakout room, I can start the creditor examination. Then we'll give him 30 days to produce the documents that are responsive to the court subpoena.
All right, Mr. McCray, I'm going to have you raise your right hand as best you can.
Yes, sir.
Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
All right, so Mr. Smith, I'm going to place you in a room with Mr. McCray, and then we can come back and put it on the record, all right?
Thank you, Judge.
All right, so we'll put Mr. Smith, you should get a prompt to go to room 1, and Mr. McCray, you will also get a prompt to go to room 1.
Okay.
All right, so Mr. Bears, you're here on Discover Bank, is that correct?
Yes, Your Honor.
All right. All right, so we're on the record in docket 2500323. That is Discover Bank versus Victor Wells. Appearances for the record, Mr. Bears.
Good afternoon, Your Honor. Jeffrey Beers, P 41693, on behalf of plaintiff.
Good afternoon. And you are Melissa Patrick?
Yes.
All right, you can state your appearance for the record, Ms. Patrick.
Sure. Melissa Patrick on behalf of Victor Wells, who is here to my left.
All right. This is the time set for a motion in the matter. I am in possession of the motion. Did the parties want to meet before we do the motion for summary disposition. Mr. Bears, would you be interested in talking to Ms. Patrick concerning the motion for summary disposition? I have the motion. I don't have a response, but
Yes,
but I do have the motion filed July 7th.
yes, we can talk.
Yes, please.
All right, so Ms. Patrick, so Mr. Bears, I'm gonna place you in room 2. And then we come back and put it on the record. And Ms. Patrick, I'll place you in room 2 also. And then the rest are Smith. Do you have a case here today, ma'am?
Yes.
What's your name?
Jaime Williams.
All right.
Also with Black Cube.
Yeah, that's a discovery hearing with Mr. Smith. We'll call that in probably a couple minutes. He's got to get out of the breakout room. Yes. All right, so we're back on the record in docket 1602842. That's Lafayette versus Don McCray. And Mr. Smith, did you have the opportunity to speak with Mr. McCray in a breakout room?
I did, Your Honor. We had an excellent discussion. We've got a solution in place to take care of the remaining balance on this judgment. For all intents and purposes, the creditor examination is complete. We have no need for a further court date at this time. And I'll be in writing to Mr. McCray, reminding him how to make his monthly payments so we can retire this particular judgment.
All right. Is that a fair statement, Mr. McCray?
Yes, sir, it is.
All right. So the discovery hearing is done, and then we'll wait. Well, there's no order to follow in this case.
In order to follow,
the
Your
case
Honor,
is all set.
ban complete. Thank you.
All right. Thank you. You should be all set on 1602842. And Mr. McCray, thank you for your appearance. You're all set.
All right. Well, thank you both, gentlemen.
Thank you, Don.
All right. Take care. Thank you.
And then, Mr. Bear, are you back on Miss Patrick's case?
Yes, we have a consent on that.
All right, let me bring that up. After I bring back Miss Patrick. All right, so we're on the record in docket 2500323. Mr. Bear, you said you had the opportunity to speak with Ms. Patrick and her client in a breakout room. What, if anything, came from that meeting?
That's correct, Your Honor. And it's my understanding we have a consent judgment as follows in the amount of $13,088.59 with the additional order that defendant shall have the right to file a motion for installment payments within 21 days of entry of the order.
And Ms. Patrick, is that your understanding of the consent judgment?
It is, Your Honor. Thank you.
All right. And Mr. Bears, did you plan on having Mr. Wells and Ms. Patrick, did they have your authority to advance to the court for signature of the consent judgment, or do you need for them to review it? Either way works. Either way works for the court.
If they want to give me authority to sign their name to it, then that's up to them.
Let's take a look at it.
All right.
All right.
I'll email it to her.
Okay.
All right. So Mr. Bears will send the order over for Ms. Patrick and Mr. Wells. Look at it. Once it's signed, you can advance it to the court. So I'll await the order to follow after it's been reviewed. Anything else for the record in docket 2500323, Mr. Bears?
Plaintiff has nothing further.
All right, Ms. Patrick, do you have any questions of me, or are you all set?
I'm all set, Your Honor. Thank you.
All right, thank you. Thank you for your appearance today. You're all set.
Thank you.
All right, so we're on the record in docket 1800898. That is Lafque versus Anthony Budd. Mr. Smith, your appearance for the record.
For plaintiff Lafque, Tim Smith, P48259.
All right, this is the time set for a motion to show cause. We previously met on July 15th. This case was called at 3:42. It's now 3 o'clock. The defendant had failed to appear for the discovery hearing, and we set the show cause. This was set for 2:30. It is now 3:31. It would appear that Mr. Budd is not in the Zoom courtroom or physical courtroom, and nobody answers by that name in the hallway. It appeared the defendants failed to appear for the show cause hearing. Mr. Smith, how did you want to proceed?
We'd request a bench warrant, Your Honor, for bond consideration purposes, balance on the judgment, $1,798.07.
98. All right, so the orders to follow concerning the show for the non-appearance for show cause in the amount that is the underlying amount, that would be the $1,700.
Do you want it at 1,700 or 1,798.07?
1,700. We'll make it for the actual amount.
The actual amount. So we'll cash bond $1,798.07. We'll prepare and submit that warrant.
All right, thank you.
Thank you, Your Honor.
Oh, all right. That's all for the record in 1800898. And then Ms. Williams, you can come up here. And then we're on the record in docket 1801709. And that is Lafque versus Kamira Williams. Appearances for the record, Mr. Smith.
For plaintiff Lafque, Tim Smith, P48259.
And ma'am, you have to correct my pronunciation. It's Kamira Williams? Kamira Williams, thank you. This time set, we met on July 22nd. And it looks like this was a 30-day continuance out for September 9th of today's date for some documentation. Mr. Smith, how are we proceeding today?
It's really not, I'd like to proceed. There's nothing I can do. We had sent a letter on the 23rd of July after that hearing reminding the defendant exactly what documents she had to produce. They related to 3 different employment relationships, 4 different banking relationships, and a vehicle title and registration. After sending that letter to her at the address she confirmed, we mailed that out July 23rd. We've received nothing from her. I can't proceed today. I have no documents. So perhaps the court can explain to her why she needs to produce these. We'll give her 14 days to get paper copies to my attention. Otherwise, we got to come back and deal with this in a different fashion.
All right, Ms. Williams. Did you not understand what you had to provide for this, for the documents?
Yes, sir, I understood.
Okay, and what was the problem?
I can't afford to make as many copies as he needed.
You needed a copy of each document.
Yeah, he wants.
So did you share that with Mr. Smith that you cannot afford it?
No, I just found this paper literally last night before I came today because I knew I had court.
But it was July 22nd is when we set this date.
Yeah.
So we set it for almost 6 weeks.
I lost the paper and I had a lot going on. So that was my
But
fault.
this should be a priority at this point.
That was my fault and my error for
Okay.
not being able to find the paper like I should have.
Well,
That's why I said I don't mind sending the papers.
All right.
will send them. I'm just not going to go and make that many copies if I can't afford it.
Well,
If I can get an email address to send all of them to, I'll do it today.
All right.
I have the copy.
Mr. Smith, would that suffice an email address?
No.
Or you need an hard copy?
Our IT team, no strange emails with strange attachments are going to clear our firewall. I'll give her a fax number if that helps.
Can you fax it instead of send the copy?
I'm still gonna have to print them out. I can't send a fax from a copy that's not physical. All
Okay.
of my bank statements are electronic. So I would have to go to the library, pay for each copy, which is gonna be about 5 pages each. For every statement, which is 6 months worth of statements, that's at least 20 copies for just one account alone.
All right, so
That's why I'm saying,
so-
I don't mind sending them.
Ms. Williams is indicating she can't afford to make the copies of each bank statement.
Well, the subpoena requires 6 months. Here's what a compromise I'm willing to reach. Now, her paycheck stubs are certainly available. The registration to her vehicle is certainly available, the title to her vehicle. There were many things that she could have sent, but she sent nothing and she didn't even call, Your Honor. This is a stall. But in a spirit of compromise, we need copies of the paycheck stubs for Appletree, Gildan Woods, and Fresenius Kidney Care. We'll do simply the last month, not the last 6 months, but just simply the last or most recent monthly account statement from the 4 institutions that she banks with, as well as registration and title. And I think that's a very fair compromise.
All right, I'm gonna indicate that we'll do it in 2 weeks. We'll set, and I don't know what we look like.
Your Honor, I have 2 jobs and I don't bank with 4.
You have to get the documentation. You've had 5 to 6 weeks.
I know, but he's.
I'm ordering you to
properly.
get the documentation.
Jobs.
If you don't get it to documentation, you can spend time in jail, all right?
Sir, I'm asking you.
And I'm saying no.
You're not understanding me. He's saying Appletree and Gildan Woods are 2 different places and they're one.
Okay.
That's all I'm trying to clarify.
We want the last, Mr. Smith,
He's saying.
once again, for the record, tell Ms. Williams what you want.
I'd like the most recent paycheck stub for each place of employment. Fresenius Kidney Care, and if Appletree and Gildan Woods is the same thing, that's fine. But for every place she's currently employed, most recent paycheck stub, the subpoena requires 6 months of monthly account statements, but sends simply the most recent month, a singular month, the most recent month, Huntington, Cash App, Apple Pay, Chime, and then registration and title of the vehicle. All of that was listed in the letter I sent on July 23rd.
I have the paper, and once more, Apple Pay is not a bank, and neither is Cash App. So
Your Honor, we have people every single week of the month who are able to print it, because so many people use these online banking situations. We get Cash App, monthly account statements from Cash App, Apple Pay, Chime. Chime is through Sutton Bank. It's very easy to get, and I don't know why, other than it's a stall, it's difficult for Ms. Williams.
You have 2 weeks, ma'am. You have 2 weeks to get the required, what Mr. Smith has indicated, and a 2-week date within the reason of 2 weeks, because I have to look at the court schedule.
September 22nd at 10.
Okay, so September 22nd.
1 second, so I can make sure I don't work that day.
At 10 o'clock. Ma'am, you don't work that day. September 22nd at 10 o'clock. And if any of these present a problem that you cannot sell, you should call Mr. Smith. And you have the number's on the paperwork. But I think this is an adequate resolution to this problem that has started on July 22nd. Okay, July 22nd is when it started. So this is almost, well, it's exactly 2 months, 8 weeks. So we'll set it for September 22nd at 10 o'clock for the continuation of the discovery hearing. After that, I will entertain a show cause or warrant request concerning the failure to provide discovery in this matter. Anything else for the record in docket 1801709, Mr. Smith?
Nothing for plaintiff, Your Honor. Thank you.
All right, thank you. Ms. Williams, do you have any questions of me? All right, thank you. You're all set, ma'am. Thank you for your appearance. Let's go back on the record. Okay, so we're back on the record in 1801709. Ms. Williams, you indicated you had a question.
Yeah.
All right, for the record.
So after I send him the paperwork, I still have to be here?
After you send the paperwork, until you hear differently from Mr. Smith or myself, you still have to be here.
He's gonna have me come here because he doesn't like me. Thank you, sir.
Thank you. So September 26th at 10 o'clock.
26th or 22nd? 22nd.
September 22nd at 10 o'clock.
Yes.
All right, and then I think you have some 3 o'clocks, Mr. Smith. Is that correct?
I have 2, Melvin Ware and Ann Izalde.
All right, let's call, I think we can call your first. That is Melvin Ware. So we're on the record in 17-02461. That is Lafkew versus Melvin Ware. Appearances for the record, Mr. Smith.
For plaintiff Lafkew, Tim Smith, before 8259.
All right, this is the time set for a discovery hearing This was set for 3 o'clock. It is now 3:40. I do not see Melvin Ware in the Zoom courtroom or physical courtroom, and nobody appeared by that name in the hallway. It would appear that Melvin Ware has failed to appear for the discovery hearing. How did you want to proceed, Mr. Smith?
We'd like to file a motion to show cause, Your Honor. And just for the record, right after the services of subpoena, I did get a call from Melvin Ware. He claimed this isn't me. During that phone call on June 20th, he confirmed not only the social security number, but the date of birth of the individual against whom we have the judgment. So I'm very confident we served the personally served person. That being said, he's failed to appear today. We'd like to file a motion to show cause and have 9-day mailing on the service to the address at which the personal service was effectuated on the underlying subpoena.
All right. I will grant the motion to show cause verbally and sign the order when it's made available, order to follow with 9-day service.
All right.
Anything else for the record?
Nothing.
Go ahead.
We'll prepare
Anything
and
else for the
submit.
record? All right. Thank you. So that's all on 1702461. And then we're on the record in 21-01376. That is Lapke versus Ann Elizalde. Appearances for the record, Mr. Smith.
On behalf of Plaintiff Lapke, Tim Smith, P48259.
Okay, this is the time set for discovery hearing. It was set for 3 o'clock. It is now 3:42. It would appear that I do not see Ann Elizalde in the Zoom courtroom or physical courtroom. There's nobody by that name in the hallway. It appears that the defendant has failed to appear for the show cause, scheduled show cause hearing. I'm sorry, the discovery hearing. And Mr. Smith, how would you like to proceed?
I'd like a defense failure to appear. We'll file a motion to show cause, Your Honor. We'd ask that service be effectuated via 9-day mailing to the same address at which personal service was effectuated on the underlying subpoena.
Yeah, I will verbally grant the motion to show cause for the fail to appear for the discovery hearing with a 9-day notice at the same address. Anything else for the record in 21-01376, Mr. Smith?
Nothing, Your Honor. Thank you so much.
Thank you. We are all set, Mr. Smith. Thank you for your appearance today.
Okay, thank you, Judge. Have a great day.
You too.
Sorry, Mike.